Bang.
Morning,
Morning,
members.
colleagues, honorable members.
Good morning, Mr. McDonald and other members. I just got a call from Chair. He's flying to Cape Town today, so he's working from an office at the airport. So he will be connecting a little bit late, 5 minutes later, if members can be a little bit patient. So the meeting will start at around 9:05, please. Thank you.
All is well. No
How are
problem.
you? How are you? Are you well, Mr. McDonald?
Vanity,
Yes, I'm okay.
Vanity.
I will not be available most probably next week for a couple of meetings because I'm having a tumor removed. So next week I will send you a note. Vanity.
Sure. I will take note of that. I hope you
Valerie?
get
Valerie.
Hello, Mr.
Valerie?
Sitole and Mr. Chabangu.
Yes,
Yeah,
my
yes.
dear. I want to put an apology that I will be excused at 11 because I'm going to Cape Town. So my flight is at 2 o'clock.
Yeah, Chair also indicated that his flight he has to leave the meeting at 11:45. So, yeah, I'm taking note of that. Yes.
Yes, I didn't even out of
Mama Ramadwa. Mama, who's an honorable Ramadwa?
Rioner Busange.
Divugilo.
Uthini? Uthini? It's raining in Cape Town.
Oh, you're in Cape Town now. Okay. Do you have my? Remember what?
Oh,
assignment I gave
okay,
you?
okay. I'll do follow up.
But you see. Okay.
you two must not talk private matters here, man.
It's not private.
I can hear it's private in a way. How are you?
I'm fine, and yourself, my brother?
I'm fine also. Are you in Cape Town?
Yes, and it's raining.
I've not been in Cape Town from February last year, ever since I was sick.
From last year.
Yes, February. But I'm coming. I'm coming. Next month, I'm coming.
Okay. But today
Okay.
you are coming.
Visual, that election of the speaker.
No, it's not virtual. Mankosi, it's not virtual. It's physical.
Yes.
All of us is called.
So if I can arrange a flight tomorrow morning.
We are starting at 11 tomorrow.
Okay.
As long as you will arrive at 11. Before 11.
I'll see what I can do.
Didn't you know?
I knew, but we've got commitments. You know, there are political commitments that we must give preference.
Okay.
Okay.
No. Enjoy the rest of your day, Baba Shabangu.
Bye, ma'am.
Reko thoma nga tshifhinga.
Aye, ufir do thoma after 5 minutes.
Oh, nda vuwa.
Ro vuwa ri vusa ngeyo.
Hayi na nne ndi khou vuwa khakhathi ya hu na fhedzini weather ya Cape Town ai khou takisa nga maanḓa.
Hayi, ai khou takadza na luthihi. Hu khou rothola mvula I khou na.
Mara ri pano na ndi nga parliament nga ofisini.
Vha phalamendeni.
Ndi khou shuma zwino.
Okay. Hayi ndi village.
Mara na after meeting ndi khou ṱuwa ndi boela village.
Oh, okay. Hayi zwavhuḓi ḓuvha ḽa vhuḓi.
Recording in progress.
Hey, where's Comrade Mangu?
I'm here, my comrade. Good morning.
How are you, my friend?
I'm good. Good. Complain. How are you?
You are not audible enough, man. It's a long time that I've not been speaking to you.
A long time.
Oh, that's fine. We'll meet. Thank you.
Oh, my brother. All right.
Okay, my brother.
Valerie.
Good morning, Chair. The members are in the meeting corates. The apologies are from Mr. May and Ms. Noluchungu.
Okay.
Good morning, honorable members.
Good morning, Chair. Good morning, Chair.
Good morning.
Morning,
Mangete,
Chair.
Good morning.
I am talking to you whilst I'm at the OR Tambo Airport.
Where is that?
Right in Joburg.
Oh, not Afghanistan.
Yeah, no, right in Joburg. I have already made my arrangement to visit Cape Town for Thursday. So around 11:45, I will request to leave the meeting so that I then go ahead with my preparations. Otherwise, I'm ready to go. That is why I asked for 2-3 minutes just to settle down. Otherwise, a very warm welcome. Honorable May and Honorable Valerie, who's not in the meeting.
And Ms. Noluchungu is also not available today. Those were the apologies from the members. I haven't received anything from the department from today. The letter from the DG yesterday said that he was not available for deliberations, but he didn't state the date. And the apology from the minister was yesterday. I just saw what's upcoming from the PLO chair that says that she will disconnect at 9:30 because they are at COPA with the Road Accident Fund. And the minister and the deputy minister are also connected. I'm not sure if it's for this meeting or for the COPA meeting, Chair.
Thank you very much, Valerie. Honorable members, I'm sure we are ready to start. Our agenda today is a continuation with the traffic amendment bill. We went up to clause 6. Am I correct, Valerie?
Yes, Chair.
And
Honorable Chairperson, Honorable Chair, sorry.
Okay, who's that?
Is Chris Lavisa from Transport, Honorable Chair?
Yes, Babu Shabisa.
I just wanted to indicate I heard Valerie talking about the presence of the Department of Transport. I just wanted to place on record that yes, we are here. I'm from the roads branch, and also we got Advocate Mahato, who's a project leader of the project or of this bill. And then also we've got Mayor Padziri, who was from the legal services from the Department of Transport, as well as John Mutsatsing. We are all here, the four of us. Thank you very much, Chairperson. I just wanted to put that thing on record. Thank you, Chair. And also we do have Tandi Wempondo from the Office of the Minister. She's here. So I just to place that on record. Thank you very much, Chairperson. Thank you.
So where is your DG, Babu Shabis?
DG, I think it's got other assignments. We wouldn't know, but I think there are other assignments. Yes, he has been, assigned with the minister. I haven't had, that's why we are here, just to represent the office of the administration from the DG's position. Thank you very much, Chairperson. Thank you.
The procedure is that if he is engaged on other issues, he should duly apologize and indicate who is going to be representing the department. But be that as it may, I hear you. Thank you for clarifying. I have heard that the deputy minister is here. Am I correct?
No, Chair. Sorry,
yet.
Chair. I just got a clarification from the PLO. The deputy minister and the minister is attending the SCOPA meeting with the Road Accident Fund today. They're not here in the meeting.
Okay, thank you very much. Let's forge ahead. Advocate Nell has to start with the clause 7. and clause by clause we move. Advocate Nell, are you ready?
Morning, Chairperson. Yes, I am ready. I'm going to be toggling between the screens again, as the members are used to this split screen presentation. So I'm just connecting the screens.
Thank you very much.
Chairperson?
There is somebody who's chairpersoning me, Honorable Honorable Hansinger.
Yes, good morning, Chairperson. My apologies for interrupting. I was only able to rejoin now. So good morning to you, therefore. And my apologies again for interrupting the proceedings as we assumably wanted to start with where we were. Chairperson, the reason for my interruption is with regards to the matter which was raised yesterday, where we did not have the legal representation present as what we have today. Yesterday, the report of the illegal conversions of taxis, of panel vans to taxis the report was accepted by the committee. And one of the major concerns relevant to today's meeting was the relationship between NRCS as an entity under the Department of Trade and Industry and the relationship with the Department of Transport and the relevant traffic entities that we have. And the conflict and the gaps that occurred in our investigation based on shortfalls that we have in current legislation. Now, yesterday, as part of the conclusion, it was raised that today, indeed, we are dealing with one of these pieces of legislation that need to be bolstered. And therefore, Chairperson, I took the liberty of just refocusing the committee through you, Chairperson, committee members' attention to the opportunity that we have in strengthening this legislation to close the gaps that we currently experience, particularly with the matter on the table with the converted panel vans to taxis. But then there are also other matters. Currently, the whole issue is quite speared up in the vehicle trade industry with daytime running lamps, homologation certificates that are simply signed off, and absolutely havoc in terms of what is legal and not legal, making it really difficult for our law enforcement staff, traffic, and organizations within our ambit in terms of the Road Traffic Management Corporation and Road Traffic Infringement Agency. So, Chairperson, I just want to sensitize our members for the opportunity that we have. And I'm asking through you, Chairperson, for the assistance of our legal experts to then show and indicate where these specifics can be altered to then, in fact, improve our legislative paradigm. Thank you, Chairperson.
Thank you very much, Honorable Olsinger. I think you are correct. That issue was raised yesterday. And I did, of course, raise the fact that as we deliberate today, it is an opportunity to raise issues that we think will help us going forward with this bill. Enkosi kakhulu, lunga elihloniphekile. Advocate Almanel.
Thank you, Chairperson. Today we are going to carry on from Clause 7. Clause 7 amends Section 3I of the Principal Act. Chair, I'm just showing members my note here that I made during the presentation that the department did, the Annexure A presentation on page or slide 30. There was an amendment proposed by Ms. Swanepoel to have an addition here, especially for this bottom section of this bill, an addition, and the department agreed to that. You'll see here in the bill, it just refers to, in terms of the applicable law, and the proposed amendment received in the submission is that we need to give reference to the Criminal Procedure Act, so that when the vehicles are impounded, it will assist if a vehicle is impounded in terms of the Criminal Procedure Act, that it can be used in terms of evidence. It's also, I'm just going to minimize my notes, just go there. That was the slide. So the proposal there is just to have the addition here at the bottom to read that the officer must deal with the impounded motor vehicle as deemed by section 30 to 36 of the Criminal Procedure Act as applicable. And here the department indicated that it is to be considered for incorporation. So Chair, then just going back to show members what the Principal Act looked like. So minimize that one, okay. So Chair, this is adding paragraph Q, so the Principal Act A, B, C, D, E stays the same. It's the powers and duties of traffic officers. And we are going to get to Q here at the bottom. So Q is a new addition to section 3I. So Chair, the new one is proposed if he or she is satisfied on reasonable grounds and subject to verification by the traffic officer that a motor vehicle was in the past issued with a notice to discontinue operation in terms of section 44(1), and such notice was not complied with, is being operated on a public road by a driver who is not a holder of a valid driving license, is being operated on a public road by a driver who is not a holder of a valid professional driving permit, or is being operated by a person without the necessary operating license or permit, or contrary to the conditions thereof, may impound the vehicle pending the investigation and prosecution of that person for an offense in terms of any applicable law. So Chair, that was the original proposal in the bill. If members prefer the formulation that Ms. Swanepoel proposed, we would need indication there from members whether or not we need to just make sure that the A list has this indication in there. Chair, the reference to the Criminal Procedure Act does assist because in many instances when, for example, contravening vehicles, such as some of the public transport vehicles are impounded, they are often released just by a payment of the fine or the impound fees. And then they would be sent back with stipulations that they need to make sure that the vehicle is compliant and does not get impounded again. This does not always happen. When you do allow them to impound a vehicle in terms of the Criminal Procedure Act, the vehicle gets to stay in there for any possible criminal proceedings. Let's say a vehicle is used in a hit and run. They can then impound the vehicle in terms of that act. And keep it in evidence for when the court proceedings go. So it just strengthens the rights of the traffic officer, and then to also then link it to the Criminal Procedure Act so that they can't just take the vehicle out by paying a fine or the impound fees. So Chair, that is the addition on clause 7 for members to consider.
Honorable members, let me hear by a word of mouth. What are your views, Honorable Chris Unsinger? Am I audible, members?
Yes, thank you. Thank you, Chairperson. Thank you. Chairperson, I would support the amendment as laid out. There was just one particular matter that was raised by Advocate Nell with reference to the wording that she said subject to a driving license, and I didn't quite clearly hear the connection or the relevance of that in relation to this particular clause. Can I just get clarification on where the relevance lie in what I heard to be a condition whereby the driver should have a driving license in order for action to be taken. My sound just had a relapse. If I could just get clarity on that, Chairperson.
Advocate, clarity, please.
Chairperson, it is here on Q2. So if the traffic officer pulls a driver over and they then determine that the driver is operating their vehicle on a public road, and that person is not a holder of a valid driving license, or in the following one, a PDP, they have the powers, it's a discretionary power here, they may impound the vehicle pending the investigation and prosecution of that person. Chair, this is a clause that brings the Act in line with concerns or similar clauses that we have around the world, where vehicles, if a person is pulled over and they're operating a vehicle without a driving license, I know in some international states, they allow the person to either call somebody, or if the passenger is able to do so and they have a valid driving license, they may drive the vehicle. But if there's no option available for the person to drive that vehicle has to be impounded and removed from the road. In the past, it's something that they would just lock the car on the side of the road, but these days we really cannot just leave a vehicle on the side of the road until the person can come back or bring somebody else. The vehicle on the side of the road is a distraction, and it can also be a safety hazard. So, Chair, I think the department can also elaborate, but that is my understanding of why they would want to bring this in. It may also be linked to the provisions in ARTO for demerit points for driving without a driving license. So the department can also shed light on further motivation as to why they would want to link the driver not holding a valid license with the impoundment of that vehicle.
Sure. Advocate Makatu, you want to say something?
Thanks, Chairperson. Advocate Nell is true and correct, Chairperson. What we're trying to do is to augment the powers and duties of traffic officers. And as she correctly stated, it would not be safe to leave a motor vehicle lying around on the side of the road. What we're trying to do is to simply get that to the nearest safest place, and those would be the impoundment facilities. And in that way, the owner thereof will be able to come and attend to paying the necessary fees and attending to the offense that they might have committed. And then with that, will enable them to, the vehicle itself would be released, Chairperson. So yeah, that's the long and short of it. Thank you.
Of it, Honorable Unsinger.
Thank you, Chairperson. I'm comfortable with that and propose that we support that improvement in the legislation.
Comfortable, supported. Let's get a seconder.
Honorable Chairperson, I'm seconding.
Thank you very much, Honorable Ramata, for seconding. Any other view? Going once, twice. Thank you very much. Let's forge ahead, Advocate.
Thank you, Chair. Our next clause is clause 8. It deals with the substitution of section 3L. Okay, I'm just going to go to 3L in the Principal Act. There you go. Okay, 3L's heading will then also change. The old provision was the approval of training centers. So both of those sections there will be removed. And this will be the new 3L, which is training center to be registered. So the new clause will read, a provincial department responsible for transport or a local authority shall not offer authorized officer qualifications unless it has been approved, registered and graded as a training center in terms of this act. Now, Chair, I know there were some comments and concerns about the fact that this reference to the shareholders committee is now removed, but I just made a little note here. The new provision will remove the current clause for input from the shareholders committee. However, it is brought back in the new proposed section 3.0, which we will get to momentarily. Then there is also a proposal there from the Department of KZN, Department of Transport and KZN, as we can see on slide 25. There's slide 25 on 3L. They had an issue here with reference to a person being in there, but Chair, I think their reference here in the slide to 3L should have actually been somewhere else, which is why I indicated there that it's actually for 3M. But Chair, this clause should not be read in isolation. 3L must be linked to the new provisions that we'll see in clause 9, which is 3M, N, and O. So I just thought that I would point that out to members, and then we can just get members' input before we go to clause 9. Chair.
Members' input before we go to clause 9. We are dealing with clause 8 now. Let me see hands if there is any input. Ubaba Ulisa Wagwamangu, followed by Ubaba Unsinger. In that order, please.
Thank you once more for the opportunity, and good morning to everyone. Chair, I'm in support of the other proposals. However, in supporting, I would like us to satisfy ourselves when we get to O, the reintroduction of the shareholders committee or input thereof, because I believe it is very, very critical that we do not erode the role and responsibilities of provinces in these matters, since they are a concurrent function. Thank you, Chairperson.
Baba Chris Hunsinger.
Thank you, Chairperson. Chairperson, I just have a concern by implication in that it is mentioned how the authority is not to be transferred without reference of how it then can be transferred. So I align with my colleague, Honorable Mangu, in that we reservedly accept this on the basis that it should align with M, N, and O of the clauses. Thank you, Chair.
Thank you very much. Any other hand for something different? Or do we agree with the views of the members? Ubaba Uketa Mabala Ustole, I'm told that we are in the same plane, me and you. So you want to leave at 11 a.m. Honorable member, you can forge ahead.
Thank you very much, Chairperson. Chairperson, if they can actually, I want to check that the comment from KZN, because I couldn't understand that one. If they can install it, Chairperson, so that I can check it on the side.
Why do you want to check the comment? Is it because you are also from KZN, honorable member?
No, because I'm national, so now I'm checking broadly on national issues.
Oh, you are broadly checking on national issues. Advocate, can you repeat that issue on KZN?
Yes, Chairperson. I think we will get to the input here. It's a very small display here on the screen, so I'll just make it a little bit bigger there for members. So members will see here in the department slide, they link the comment to 3L. But if we look at 3L, there's no reference here in 3L to a person. So it is actually to 3M. If you look here, based on what the department indicated here. 3M is the ones that we will get to now in clause 9. But the concern of the KZN department was when we do draft legislation and there's reference to a person, it might be a bit difficult to determine who is actually the one that you are referring to. So they are saying here 3L makes reference to a person delivering authorized officer qualifications. This is also mentioned in section 3M and implies that a private person may train traffic officers, driving license examiners, and vehicle examiners. The KZN Department of Transport does not support this amendment, and it is proposed that where reference is made to no person in section 3L and 3M, it be removed. So members, I will point that out when we get to the references to a person, no person, just so that members are made aware of that comment. Then also just to show here that the department indicated as it relates to that comment that it accepts this, and the department indicated that it is affected. So we will just go as we go through clause 9 to make sure whether or not that was implemented or whether or not the committee will then decide on either using no person or rather refer to an official or something more specified.
Baba Keta Mabala, usuyitholile baba ngithi.
I'm covered, Chairperson. Thank you very much.
Thank you. So can we then move to clause 9, Advocate?
Thank you, Chair. Members will see here that clause 9 is all new clauses. There is no MN and O in the Principal Act, so I'm just showing the Principal Act there to members, and this is what the bill now seeks. No specific additional notes other than these clauses. As indicated, there's reference back to the Shareholders Committee. We see them both in M and N. So hopefully this should link up with training centers that have to be registered, and then also how a training center is registered or graded or the application thereof. So Chair, hopefully this will also assist with the concerns raised by the members. Okay, just going to take members through 3M. So the new clause, application for registration of training center. 3M1, a provincial department responsible for transport or a local authority desiring to offer qualifications for authorized officers shall apply in the prescribed manner to the Shareholders Committee for registration as a training center. 2, a training center may, on the prescribed conditions, be approved, registered, and graded to offer qualifications for traffic officers, examiners for driving licenses, examiners of vehicles of traffic wardens, or a combination thereof. And 3, a provincial department responsible for transport or a local authority shall not offer qualifications for authorized officers unless it has been approved, registered, and graded as a training center. So Chair, we'll see here, especially 3M3, almost identical to 3L. So I'm just going to take members through 3N. Registration and grading of training centers or training center. 3N, on receipt of an application referred to in section 3M, the Shareholders Committee shall, if satisfied that in relation to the training center concerned, the prescribed requirements have been met, register and grade such training center in the prescribed manner and give notice of such registration in the Gazette. Then Chair 3.0, suspension or cancellation of registration of training center. So Chair, we'll see here 3.0. This is why I'm saying it's definitely catered for and linked here to the old 3L2, because that was where it's when the training centers are not complying, what happens. So 3.0 deals with those issues. 3.0, the shareholders committee may, if a registered training center no longer complies with the requirements referred to in section 3L, suspend the registration of that training center for such period as it deems fit, or regrade or cancel the registration in the prescribed manner and subject to due process of law. So Chair, that is clause 9. Clause 9 is an expansion, or at least in my opinion, or how I see it, it's an expansion of the old 3L. It gives a bit more clarity, and it makes sure that those new additions that we had for wardens, that we discussed earlier in the bill, and training officers and the like are addressed here and linked here too. So Chair, that is clause 9 for members' input.
Let's hear members. Thank you, Advocate Baba Ulisa Mangum.
Chair, thank you. Thank you so much. If maybe we could get back to that first line on the new 9 or proposed 9, please. However, my question to the department through you, Chair, is the anticipation that nobody else is allowed or will ever be allowed to offer training, because the reference seems to be purely talking about a local authority or a provincial department responsible for transport. That is my clarity-seeking question, Chair, and if I could be assisted. Thank you, Chair.
Thank you, Baba Ulisa Wagwamangu. Advocate.
Thanks, Chairperson. Normally, the training centers, they would be run by provincial departments or a local authority, as the case may be. And so that being the case, and amplifying the point, maybe let me just address that. Yes, envisaging that it will be provincial and local authorities. And what I also want to add to what Advocate Nell has said is that indeed with M, N, and O, we are amplifying section 3L as it sits there by making those necessary additions, Chairperson. Thank you.
Honorable Mangu.
Chairperson, I don't know whether, because I'm also with my colleague, Mr. Motsating, so that he mustn't feel left out. He can, with your permission, maybe add.
You must not make your colleague feel good at our expense, Advocate, please.
I'm sorry, Chairperson. It's just that I work with him on a daily basis, and the leader of the delegation also recognized him that he is part of these engagements, Chairperson. If I'm
no, we will revert back to him if he has anything to say. Ndatemzati.
Good morning, Chairperson, honorable members. Thanks for the opportunity, Chair. I think I'll allow Advocate Makatu to lead the discussion. It's fine, Advocate. It's fine.
Thank you very much for understanding. Honorable member, are you okay?
I am okay with the response. However, I do not think it is in line with what is pertaining in the country currently as it relates to training on different aspects. I am, if subject to correction, obviously aware of a time where private institutions or colleges, if they are properly accredited, could provide certain training which relates to the subject matter here, traffic officers, examiners. I'm not sure about the examiners, but traffic officers certainly. And I am of the view that that clause 3M1 is very narrow. The response by the good advocate Makato to me is not assisting us. And unless there is something really major that we are not being told, I would propose that a consideration be made to make it broader, to allow for those institutions. I mean, if a university or any other place is capable of training traffic officers, I'm not sure why it should not also make that necessary application to the shareholders committee and so forth. That is my submission, Chairperson. Thank you very much.
Thank you very much, Honorable Manu. I'm dealing with advocates now. Is there anything that the state law advisor would want to say? Ms. Haricharan?
Thank you, Chair. Chair, sorry, my reception was breaking up a bit there. Can the question please be repeated? Thank you.
Thank you very much. The Parliament Legal Advisor, Ms. Phumelele Ngema, must also ready herself after this. Honorable Member Manu,
Yes, Chair.
Are you so kind to repeat your question before we close this matter?
Certainly, Chair. Thank you, Chair. I am saying that 3M1 currently reads proposal is a provincial department responsible for transport or local authority desiring to offer qualifications, and it carries on. My proposition, unless there is something fundamentally against my proposition, is that we anticipate institutions other than a provincial department or a local authority also desiring to offer these qualifications to be included in this proposal. That is where the comment was required. Thank you, Chair.
Thank you very much, Honorable Member, Mayor Richardson.
Thank you, Chair, and thank you to the member for that, for the query. Chair, if we may please come back to the committee on this issue. Just want to follow up on something, and if I may please come back to the committee at a later stage, please.
Okay, let me hear Ms. Phumelele Ngema. Are you also an advocate, ma'am?
Greetings to the members and you, Chairperson, and everybody on the platform. Ms. Ngema is not an advocate, but an attorney.
Oh, thank you. So how do I address you? I just address you as Attorney Ngema?
It's up to you, Chairperson.
Yes, thank you very much.
Thank you so much, Chairperson. For me, Chairperson, on the question, I believe it's a policy decision, because as the honorable member has pointed out, it seems possible that the other institutions can train and perhaps do train maybe with other kinds of degrees that they are offering of other practical institutions like technical colleges. But as I say, Chairperson, I don't see anything wrong other than to indicate that this seems as a policy decision that the department needs to guide us on. I thank you, Chair.
Thank you very much. Ms. Haricharan will come back when she's ready. Okay, honorable members, there is a suggestion that there is no harm in allowing universities and institutions which may want to train applying to the department. Can I get a seconder for that?
Second, Chairperson, Chris Hunsinger.
Seconded. Thank you very much, Honorable Chris Hunsinger. Any person who has a different view? No one. And then let's forge ahead to clause 10.
Sorry for the interruption, Chairperson. I have an additional point for which I've raised my hand.
Oh, okay. Thank you, Honorable Hunsinger.
Thank you, Chairperson. Chairperson, clause 3N refers to prescribed requirements, and relating to that in the O section, that upon failure of these prescribed requirements, a particular sanction through a decision by the committee can be taken. Now, in looking at what these prescribed requirements might be, I find them rather thin. And that then opens the opportunity for any real basis upon any decision. A training center can simply be closed or find improper or inadequate. So my pledge then is for these prescribed requirements to be more specific. Also, since I'm sure there could be some remedies rather than a simple closure of these training centers. So my request therefore is to look at expanding the prescribed requirements to be more specific, so that the grounds are vested within the Act or future Act upon which a decision can be made to then sanction a training center rather than just a simple decision as it appears to be written in its current form. Thank you, Chair.
Thank you very much, Honorable Hunsinger. Let's get a seconder for the additional proposal.
I'm seconding, Chairperson.
Thank you very much. Ubaba Ulisa Kamanzi.
I am fedding, Chairperson. However, in fedding, I wanted to also just highlight, I don't think they will miss it, but let's leave nothing to chance that, as my previous proposal is considered, that it has got some consequential amendments to the clauses below that also be taken into consideration. Thank you, Chair.
Thank you very much. Advocate Almanel.
Thank you, Chairperson. Clause 10 then amends section 5. Just going to show members my notes here. The clause adds the bodybuilder reference, where in the Act it was only a reference to builders. If members recall, we add the addition and the changes there to the definitions. And then there is also a reference to every is introduced as
Chairperson, yeah, no, I'm starting on a wrong foot today, but please, Chair, if you may.
They they are not referring to bodybuilders of human beings. They are referring to bodybuilders of cars, Honorable Manu. But let me hear you.
I was still on what you just closed now. I thought we will ratify 3-0 again. So that's why my intrusion, I apologize for that. And I had another proposition in 3-0, if I may, Chairperson. It was a question anyway. Yeah.
Okay.
We had provisionally accepted the removal of shareholder earlier, saying we will confirm if 3-0 and the other clauses does cover us there under the registration or training center and so forth. So I think, having read these ones, I will move that we fully accept the earlier consideration. And then my additional comment, which I thought I will raise, was maybe a question to the department. Is there a means of appeal provided for somewhere where whoever feels aggrieved by the decision of the shareholder committee, as in 3-0 here, suspension or cancellation of registration of a training center? Is there any mechanism which a person who feels aggrieved by that decision could appeal, and whatever the case may be? Thank you, Chair, for your indulgence. Sorry again for taking you back.
No, I can see you are thinking very hard, Honorable Member. Ndate Muzat.
Chairperson.
Yes, Advocate.
Thanks. Yes, there is a mechanism. So the answer is in the affirmative. The provisions of Section 81, Section 81 of the current Act allows an aggrieved person to lodge an appeal with the Minister of Transport, Chairperson. Thank you.
I thought I was giving your colleague an opportunity, as you said, Advocate.
No, Chairperson, he said I can continue. I think he misunderstood. I thought you would either add on what I had responded to earlier on.
Okay. No, that's okay. That's okay. Can we now forge ahead, Honorable Member Manu?
Just a bit, Chairperson. I think, is it 51A or 81? Because I'm looking at the Act, I see 51A, the right of appeal to shareholders committee.
Is that Attorney Pumelele Ngema?
Yes, Chairperson, just the correct referencing there, unless I'm missing something in terms of the Principal Act.
Okay.
Okay. I would let me do a reference as well with your indulgence, Chairperson. Thank you.
Okay. Advocate Almanel, are you able to assist us?
As always, she is already there.
Chair, I'm just showing 51A as Pumelelo has indicated. Right of appeal to shareholders committee, though. And then it goes further there because this is an appeal to the shareholders committee. So we just need to see here.
Advocate Makhat was saying 81. I agree. This 51 refers to appeal to the shareholder committee.
51A is appeals to the shareholders committee, and then 51B is the appeal to the CEO of certain decisions. So Chair, that is 51, and then I'll just quickly go to 81 so we can just cover all bases while we are here. And 81 talks about vehicle and loads that may be exempted. So we are looking at the 51s, Chair, for purposes of
Okay,
appeal.
so it's 51. So it's 51, Chairperson. My bad there. Thanks. But in essence, there is a right of appeal, Honorable Man. Thank you.
Chairperson, are you still there? Or is the plane taken off?
I thought I'm still here. Okay, I was muted. I'm still here.
I know those coffees at the airport are very nice, Chair.
No, I am in an office properly constituted. Honorable member, I'm not on the street because AXA airport is part of our work, so I am taken good care of. Honorable Unsinger.
Chair, if I may conclude where I was through you, is that okay?
Yeah, then Honorable Unsinger will come after you.
Yes, Chair, that 51 in my view doesn't cover what I'm trying to circumvent, because it talks about appealing on many things to the shareholders committee. Now here the shareholders committee would have taken the decision, and somebody or an institution would be seeking to appeal the shareholders committee decision. And if I look at 51 without looking at it in detail, it's talking about the shareholders committee as an appeal stage for other aspects other than this one. That would be my submission. Thank you, Chair.
Honorable Member Unsinger.
Thank you, Chairperson. I was also scanning through first section 81 and then 51. 51 being the more applicable one because it directs complaints and appeal processes to the same body, being the shareholders committee. And I think because this is not a general matter, and my initial thinking and interpretation is that 51 would be applicable for general appeals because I'm immediately thinking of the remedial action following a successful appeal. Would this then mean that the minister can simply reinstate the training center? I would assume no. There would be particular processes. And therefore, I would suggest in alliance and concurrence with my colleague Mangu, that we look at this in more particular detail and make provisions for specification of an appeals process and direct that to the appropriate person that can then also with procedures intervene and remedy a situation, because probably, rehabilitation of some sort in getting the requirements which has been sanctioned fixed again, or an intervention or facilitation is needed, which all then refers to a particular process and procedure different to general requirements, which I would argue would need a particular reference and specification. So, Chairperson, therefore, I would suggest that we look at this specifically, and that we get some additional sections under clause 8 that would make provision for appeals with a process and procedure that would wedge into and give more detail to this. Thank you, Chair.
You done at honorable member. My wish was that we could try and also from our side, if there is anything that we want to propose, but I think the concern of Honorable Mangu is well captured. Advocate Almanel, have you captured the concern that has been also augmented by Honorable Hunsinger?
Yes, Chair. I've captured the concerns by both members. I think that the parliamentary legal advisor will just assist members as to how and where it can be added. There isn't, from a quick check of the bill, I did not see any amendments to 51 or 51A or B in the bill. So this may be a new clause that will add amendments. So Chair, we'll just get feedback before we go to clause 10 exactly on this proposal from the other colleagues.
Can we then move, Advocate, if that is properly covered?
Chairperson.
Who's that?
Ngema.
Okay, Attorney Ngema.
Thank you, Chairperson. I see Advocate Makato's hand is also up, and I was understanding perhaps he also wants to address this issue. But on my side, Chairperson, I am in agreement with Advocate Nell. The proper provisions which we would have look into to give the concern effect would be either clause 51A or 51B, but one will need to study them completely. The only issue I have, Chairperson, is that they are not part of the introduced bill, because this we are dealing with is the Principal Act. We are amending a Principal Act which is already in existence. And in terms of the rules of the National Assembly, if we are looking to engage a provision that does not form part of the introduced bill, especially if it's an executive bill, as this is the instance, we will require the permission of the House, which is another process that is run. It can run parallel with the deliberations of the committee, but as I indicate, if the changes are going to be effected in a clause that is not part of the bill introduced, then that is the process we will need to engage in. But I'm hoping perhaps the department will give us an answer that can address the concern already with the provisions that exist, while I quickly read in full context the sections that were speaking to the appeal processes. Thank you, Chair. I thought I should just add that in terms of the process and the procedures that will be required for the committee in case this proposed concern or amendment is to be given effect. I thank you.
Advocate Makatu, thank you, Mepumelele. You can now lower your hand.
Thanks, Chairperson. Whilst I also lower my hand, Chairperson, I would want to direct the committee to the provisions of Section 93A of the Principal Act, titled Transitional Provisions. It has the following. I'm not going to go through all of them, but then if you go to 93 E, it says that Section 51A, any reference to shareholders committee shall be regarded to be reference to the minister.
Mm-hmm.
Yes, Chairperson. Thank you. I hope it assists, Chairperson.
Honorable Manu.
Chair, yeah, it complicates it. It doesn't assist, Chair. Any reference to the shareholder committee shall be regarded as to reference to the minister, which means then in this instance, there is no mechanism to appeal any decision. Because if I hear Advocate Makato is saying a decision of the Shareholders Committee is a decision of the minister. So there is no higher board in this instance. Then, so it complicates it, as we would say in those days, it deepens the crisis. So in essence, I do not now have, I need to process my thoughts now here, because all I really am seeking and proposing to the committee is that we find a mechanism of anybody who's aggrieved to have a place to raise their concern. And if that place is not there, I think it is not a fair process. Many processes here, because then the recourse, which I think is undesirable, could be now a court of law, which I don't think, I don't know what the court would do. So, Chair, if with your indulgence, so that we don't hold the whole process, we've got a lot more to do. Maybe if we agree that we park that proposal and allow the legal teams to look at all these, including what Advocate Makhato has just said, and come back to us and see if it does assist us. So then we can make progress, Chair. Thank you, Chair.
Thank you very much. I think that is a progressive move. Comrade Advocate Almanel, clause 10.
Thank you, Chairperson. Clause 10 then seeks to amend section 5. Just want to get here back to section 5. Section 5 is the registration of manufacturers, builders, importers, and manufacturers of number plates. Okay, so there we can see it better. So members will see here builders, we add bodybuilders. They are removing and manufacturers of number plates from this clause. So Chair, I just want to get here to my notes here. We'll see here also that reference to every is introduced. That members will see here every manufacturer, as opposed to the current use of prescribed. When I take members through there, members will see where the prescribed and prescribed, and the any comes in just on those notes, just to note that change. And then also the clause removes reference to manufacturers of number plates. The department will just clarify whether it is extensively provided for in the clause 11's new insertions, so that we don't remove it from one side and then just leave it. But we will get to clause 11 as well, and we can just get the department's input for that aspect. But to take members through here, section 5, first things first, we are amending the heading as I've indicated there. The second one that's proposed for amendments is the substitution of subsection 1. So here, prescribed manufacturers and the likes gets taken out, and this is now amended to the following. Every manufacturer, builder, bodybuilder, or importer must apply in the prescribed manner to the Chief Executive Officer for registration as a manufacturer, builder, bodybuilder, or importer, as the case may be. And then they propose that we leave 2, 3 as is, and then do substitutions of 4, 5, and 6. So here's the old 4, 5, and 6 for members, just to go through it as I read the new ones. New proposed 4, the Chief Executive Officer may, in the prescribed manner, suspend for such period as he or she may deem fit, or cancel the registration of a manufacturer, builder, bodybuilder, or importer. Again, reference to the manufacturer of number plates is removed there. 5, the manufacturer, builder, bodybuilder, or importer referred to in subsection 1 shall, in the prescribed manner, register every motor vehicle manufactured, modified, built, or imported by him or her before he or she distributes or sells such vehicle. And then in 6, it will then read a manufacturer, builder, bodybuilder, or importer shall not manufacture, build, modify, import, sell, or distribute motor vehicles unless registered in accordance with the prescribed conditions. Now, Chair, this is also one of those clauses where the subcommittee has indicated that we might have to look at this. If we can possibly strengthen builders and bodybuilders that do conversions in the country, this might be a clause where we also make sure that that is secured, especially here when we look at number 6. Hopefully this will assist in the concerns that were raised in the public protector for illegal conversions, because the clause does say here that they cannot do those manufacturings or buildings unless they are registered in accordance with the prescribed conditions. So the department might assist here to indicate whether or not they believe that these provisions will assist in alleviating the concerns of illegal vehicle conversions. As indicated by Mr. Hansinger earlier, I would just like to point out that this was one of those concerning clauses. So, Chair, there we have section, clause 10, amending section 5 for members' input.
Let's hear from members. Any taker? Are we happy, honorable members? Let me hear or see Honorable Manu.
Chair, thank you. If you say we are happy, I'm not sure we are happy with the proposal of advocate or with the proposed amendments in front of us. Either one, I think I would also move that the department gives us clarity as to how these amendments, the way they are, will assist us in curbing the illegal conversions. And attached to that question, I'm sure the department is in possession of that report of the public protector, broadly so if they could take us to those clauses where and how they address those concerns of the illegal conversions. Once we get that clarity, I then think that we will be able to make a firm proposition, which is in line with what Advocate Nell has already spoken to, because here it talks about registration of these bodybuilders, and but people they hide behind being importers or bodybuilders and do these illegal conversions. And that is what we need to nip in the bud to the best that we can through this piece of legislation. So I think clarity a little bit from the department chair could assist us to respond properly and incorporate what we flagged in the subcommittee. Thank you, Chairperson.
Advocate Mahatu.
Thanks, Chairperson. As a department, we believe that the proposal indeed addresses the issues related to illegal MIBs. Chairperson, you must know that we go further to say in the body of the clause, because maybe let me start off by saying the intent of clause 10 in terms of the amendment, we're saying we need to regulate these MIBs, and then that there is a process that they need to follow whenever they want to be registered as such, and that is to make an application, right? And that application will be judged on the strength of what in the Act, we are saying are prescribed manners. Those will be outlined, if not outlined in the Act, in the regulations. So such a person, it's not going to be a once-off process that somebody would do. On top of that, we have a service level agreement with the NRCS, and there are certain functions that they need to perform on our behalf related to issues of homologation of motor vehicles and so forth. So, but then, Chairperson, I'm not going to be remiss to the fact that if at all the committee would want to amplify this provision to make it tighter, we would welcome such submissions, and yeah, so that we address this problem once and for all, Chairperson. Unfortunately, or the other point that an Honorable Mangu made reference to was to the Public Protector's report. I do not have it where I am, Chairperson. Yeah, let me just concede to that. And yeah, I hope it addresses the question. Thanks, Chairperson.
Thank you, Advocate. Honorable Hunsinger.
Thank you, Chairperson. Chairperson, I am not convinced that Clause 10 adequately addresses the problem. And I appreciate Advocate Mogatu's view, and quite appropriately, Advocate Mogatu's view addresses illegal changes to vehicles. Also reminding us that there are particular functions which NRCS also has, but that is not the current issue. The current issue and the current state of affairs revolves around the mandated functioning of NRCS rightfully, as Advocate Mogatu says. And we acknowledge that NRCS has a particular function which is mandated to them. But often this then is in conflict with traffic laws, and it is a separate process. Therefore, we cannot simply accept the prescribed manner as adequate within section or clause 10. Clause 10's reference to the prescribed manner does not adequately address what we are currently experiencing. So I would therefore propose, Chairperson, that in addition to prescribed manner, the functions and role of NRCS should be made and expressed subject to traffic laws. Let me give you an example. We currently have a situation with vehicle manufacturers that are bringing in vehicles with particular lighting conditions that are not accommodated within our current traffic laws. But because it is a process which is dealt with in a prescribed manner by NRCS and therefore not under the jurisdiction of RTMC or RTAA, the first time which a traffic officer deals with this is on the road, where in fact these new vehicles equipped with lights which are not legal in terms of our current legal framework then have to be dealt with. And in the same way, we sit with conversions of vehicles that are also dealt with in a prescribed manner by signing off of various homologation processes by NRCS, which unfortunately ends up being illegal in terms of current traffic law. So therefore, what I suggest, Chairperson, is that we seek ways in which we make all these prescribed manners subject to current traffic laws and regulations, and that no signing off can happen if it contradicts current traffic laws. So that the current traffic regulations and the current traffic laws determine what gets onto the road. and not the other way around. Because under the current conditions, a vehicle can get on the road illegally, although complying with all the prescribed manners. So we must bring in a condition through which the current mandated functioning of NRCS is subject to traffic laws and regulations. Thank you, Chairperson.
Thank you. Let's hear those who understand law better than me. Advocate Mayor Richard, do you have anything to say?
Chair, if I could please also come back to the committee on this point, Chair, just to look at the wording there. Please, Chair, if I may come back to the committee. Thank you.
I don't hear what you are saying.
Can you hear me, Chair?
Yes, I can hear you. Can you repeat yourself?
Yes, Chair, if I may please come back to the committee on this point, Chair. I just want to have a look at the wording of that clause again. Please,
Okay.
Chair. Thank you.
Mangema.
Thank you, Chairperson. I just quickly did a search. There is an act specific to the NRCS. Chairperson, I think one will need to study that act and then see if whatever the act dealing specifically with this is not incorporating by reference that the traffic laws should apply to this, and then we will look into a proposal if it is necessary to deal with it. But I think the department can also clarify as the extent, as the experts in the field, the extent of the application of the act that established the NRCS. But we will look into it, Chairperson. I haven't studied that act, so I really don't have any input as to how it is drafted and what it says in respect of the question that has been raised.
Honorable Mangu.
Thank you, Chairperson. I'd wanted to listen to the legal minds, as you said, but when Umengema raised the issue and Advocate Makhato of NRCS and an SLA, well, as far as I know, there is no SLA in existence with NRCS. In fact, the relationship with the department, and that is why we have this problem. We seem to be shifting the problem to NRCS, SABS, and all those entities. And that is what we are saying. We need to address it here so that it has got teeth that can bite. There is no existing SLA between the department and NRCS. So the prescribed manner then covers all the shenanigans that these unscrupulous importers and builders and whatever it is hide behind. So I fully support what my colleague is saying, Honorable Hunsinger. This needs to be tightened. We cannot rely on an SLA with the NRCS, which as we speak doesn't exist. And our report highlights exactly that. In fact, when we met the NRCS, to say the least, they don't have a clue what their job is as it relates to this. I'm putting it very mildly. Now, it is solely a Department of Transport responsibility to ensure safety on the roads through this process that we are talking of. The fact that the department gives it to this one and that one doesn't mean the department mustn't have legislation that is able to do exactly that. So I think what my colleague said, Honorable Hunsinger, I 100% support. We need to see a clause here that is explicit, that is not hiding behind a prescribed manner, because that prescribed manner exists now. That prescribed manner, and through that prescribed manner, we have all these illegally converted vehicles, which are killing people, by the way, as we are talking. Thank you, Chair.
can we try and take a route, honorable members, that will not take us going back to the department in most of the issues? If we can tweak a clause and get help from the legal minds here, I think that will assist us in moving forward. Otherwise, if we say the department should go back and do some work, it means this is the best that they could have. Let me take some hands that are assisting to that process. I think is Mayor Haricharan, followed by Advocate Mahatu, followed by Honorable Hansinger, followed by Honorable Mapena, and lastly, Ubabuketa Maba.
Thank you, Chair.
Yes, ma'am.
Thank you, Chair. Chair, I just to say that I concur with the comments by my colleague, the Parliamentary Law Advisor. Chair, we concur with them. Chair, with regards to that clause, I have to also state we are satisfied with the clause as it stands at the time that we looked at the bill. But Chair, also to say that we would require, it would assist if the department could clarify further. I do take Chair's comments into account, but if the department could provide further clarity, I think that will assist the committee. Thank you, Chair.
Thank you very much. Honorable Advocate Mahatu.
Thanks, Chairperson. In doing so, let me lower my hand. Chairperson, this is not meant to be any form of disrespect, but there is a service level agreement that we've signed with NRCS. It exists. And it's in place. Now, there is Regulation 44 of the National Road Traffic Regulations, Chairperson. And as part, by doing that, our act allows the minister to appoint any other person to assist them in enforcing the provisions of the National Road Traffic Act and its regulations. So in this instance, we've gone with one of our state departments, which is NRCS under DTIC. So, and I think it's section 7 or so, Chairperson. One, there is such a thing. Two, our act allows that. Three, Regulation 44, which we've made a responsibility of the NRCS, right? And that being said, like I said, we're not abdicating our responsibilities. We remain responsible as DOT. Provides as follows. It makes reference to powers and duties of manufacturers and builders and importers. Right? And then it lists the functions, and then at clause 5 of that, and the service level agreement that I'm referring to, we're saying that they shall perform all such duties as stipulated in Regulation 44 of the NRT regulations in its capacity as the Inspectorate of MIBs and in cognizance of and with specific reference to each case of a model number held by the MIB pertaining to compliance with the relevant legislation, standards, specifications, and codes of practice in force in the Republic. 5.1.2 of that agreement, we say the following, that they must keep records of copies of inspection sheets and reports or inspections conducted at MIBs to provide inspection report to the department on a monthly basis. That they must perform 5.1.3, perform their duties to ensure compliance with Regulation 46 of the NRT regulations and to report any changes to the department and to update the latest. I pause there, Chairperson. I thank you.
Advocate. Advocate. Advocate Makatu.
Chairperson?
I think we need to start also influencing our thinking as the department as to what the portfolio committee wants us to include in this law, in this clause. Otherwise, we are stuck in one place. As
No,
they talk, let's think of ways how to resolve this matter without really defending it. I think that will assist us moving forward.
Thanks, Chairperson. It's just that I wanted to remember when we made inputs, we started by saying, Chairperson, that we would welcome any amendments that the portfolio committee would propose in this regard. That was my opening remark, Chairperson, and so that we amplify it, right? And I would leave it there, Chairperson. Thank you.
Thank you very much.
One is not.
Let's take that order. As I've said, there are two more hands I will end with that have just raised their hands. Otherwise, let's follow the order. Honorable Chris Wiesinger.
Thank you, Chairperson. Chairperson, you introduced this particular point on the basis of contributions of how one could approach a redesign of the current clause 10. Mindful of the complication that we currently have and in appreciation of Advocate Magatsu's contribution in saying that there is an agreement referring us to Regulation 44 of NRT, which I think we should also study in parallel to all the options that are provided and offered. My suggestion, therefore, Chairperson, is a very simple one. And that is that we make all the functions of NRCS, who plays a very important role in the processing and management of homologation of vehicles, part of their responsibility with DTI, but that we make all of the functions of NRCS subject to current traffic laws. Because that then places the onus and the initiative back into the hands of the Department of Transport. In leading the process, in advising what can be approved. So the frame of reference is the current legislation of traffic laws, which is currently allowed on the road. And then one can tighten the regulations and the traffic laws to then make sure it is safe, because safety should be our primary objective. And I will appreciate that Regulation 44. And I'm sure the chairperson of the subcommittee would then engage with the department in then getting insight in the agreement, which my learned colleague Magatu then also referred to. Thank you, Chairperson.
That is a clear proposal. As members talk, let's also hear what our members saying on this proposal. The following member was to be Ubaba Umapena.
Chairperson, I think the issue is not to say that there is no current SLA which between the department and NRCS, but the issue is just to strengthen this legislation and also to make sure that the provisions thereof serve to deal with the issues that have been proposed. But I think the proposal by Honorable Chris Ansinger perhaps maybe covers this, and also maybe your input in terms of the department being maybe open to the fact that there might be some issues that the committee would like to put in place. Or one can phrase it like this, Chair, that the the current legislation and the regulation that is being referred to, as much as it is there at the moment, but the problems and challenges still persist. Therefore, it gives an issue to say that perhaps implementation is a problem, but maybe there is another dimension that can be brought into the entire discussion to say maybe there is a need to strengthen that a piece of legislation. So that is my take, Chair. Thank you so much.
Are you in line with the proposal made by Honorable Honsinger, Honorable Mapena?
Yes, I am, Chair. I think that's what I also added as part of my comment here.
Asithokoze Mhlonishwa.
Asithokoze, Chairperson.
Siragela phambili.
Viva.
Ubaba ukhetha amabala.
Thank you, Honorable Chairperson. Honorable Chairperson, I'm being covered, but there is the proposal that you put forward about either we refer our proposal to the committee to the department, or either we formulate another clause. I think, Chairperson, it will be better if we can refer that one back to them, so that they must take into cognizance the proposal that have been made by members of the portfolio committee. Thank you very much, Chairperson.
Thank you very much, Honorable Keta Mabala. You're flying from Joburg.
Yes, Chair.
Your flight is 12:15.
My flight is 1:15.
Oh, so why do you want to leave? Oh, okay. Let me leave you. Honorable McDonald.
Thank you, Chairperson. Apologies for not switching my video on. My signal is not very good. Chairperson, I'm 100% in agreement with your proposal and the proposal of Honorable Hansinger. The department needs to go back and look at this complete part here, and that the department needs to present to us this Regulation 44. Chairperson, because, with all due respect to the advocate, he was using very nice big English words, but on the ground there's problems. I've written letters to the NRCS looking for body of evidence on illegally converted vehicles. There is no such evidence. The Department of Transport and the NRCS are so far divorced that there's an ocean between them. And we can't continue like this, where people are dying every day on the roads in South Africa. And the one says, I'm responsible for this, and the other one says, I'm responsible for that, and nobody wants to take. In 2010, when this report became a problem for the department didn't even know the problems that it had with NRCS. Now they want to keep the same clauses and the same legislation into this amendment, so that and we're not tightening it up. It will just mean that more people will die on our roads and nobody will care, because the one department will say it's not our responsibility, and the other one will say, well, we can't tell the NRCS what to do. It doesn't work like that, Chairperson. Chairperson, I'm 100% in agreement with what you said. The department must go back and look at it, and I'm in agreement with what Honorable Hansinger said. Thank you very much.
Thank you very much. I think the way I hear honorable members saying is that we circumvent the problem that was raised by Honorable Manu by adding what Honorable Chris Hansinger has said. Would you repeat it, Honorable Hansinger, just to refresh everybody?
Yes, Chairperson, it simply is to make the functions of the NRCS subject to current traffic laws. As simple as that.
Functions, yes.
In other words, they cannot approve anything through application of any manufacturer or applicant of a homologation process, they cannot approve any of those content if it contravenes a current road traffic act or regulation.
Yeah, and members agreed to it. I think let's move it with that understanding, because it resolves our problems of clause 9, clause 10. Can we agree on that one, or do we have any other member who still has any other issue as we stop off clause 10? Honorable members?
Agreed, Chairperson.
Agreed. Thank you very much. Thank you very much. Advocate Almanel. I see, Honorable McD has forgotten to lower his hand because he was fighting a lot, and I know when he fights, he does not want to retreat. Thank you very much. Advocate Almanel.
Thank you, Chairperson. I think just for the sake of our team that will be working on the amendments, in that regulation that the department referred to, it doesn't specify the NRCS, but it does say the inspectorate of, and then they go on to the manufacturers, builders, and importers. Technically, that is what the NRCS is then supposed to do. They are the inspectorate. So that provision to link the condition that their work would have to be subject to the current legislation will, our drafters will just have to make sure that it is linked to a clause that deals with the inspectorate, Chair. So I thought I'd just raise that one there. And then if Chair is happy and our members are happy, we can go to, at least happy to continue with the next clause, Chair. Then we can proceed to clause 11.
I was going to clap hands. I thought if we are happy, we must clap hands.
Okay, let's continue to clause 11, Advocate.
Thank you, Chair. Members will see here, the Principal Act had Section 5. Now, Section 5 is what we've dealt with now already in clause 9. So that one has a few additions. So clause 11 adds a lot of new insertions. Now, Chair, this is where I believe that the department is dealing with all the concerns. Remember my side note here that they removed manufacturers of number plates under clause 10. But now in clause 11, we get all these extra provisions dealing with number plates in all aspects. So, Chair, the Principal Act is going to be just covered a little bit with my notes here because we are looking at everything new. Chair, just to go through my notes and just refresh members on the submissions that we've received. There were comments from the Western Cape Department of Transport on slide 17. So I'm just going to flag slide 17 there. The Chair will see here that the department indicate that they do accept the proposals for 5J and 5L as indicated by that department. Sections 5J to L will now refer to the MEC, and members will see here it does actually do refer to the MEC here in 5B. We'll get to L and K a little bit later. So I just wanted to make sure that members remember that submission. And then, Chair, just the submissions of the number plate associations as well. The submissions of SANA must be thoroughly considered in these clauses. The only thing, Chair, my side note here, I could not find the department's replies to SANA's submissions in that Annexure A, so the department can just indicate where that is, or whether they do have a reply, or whether they agree with them. But based on what SANA indicated, the Act defines number plate, and the SANS, National Standard 1116, clearly differentiates between a blank plate and a number plate, since it is two separate items, and reference should therefore, according to SANA, not be made to a blank number plate. They propose the revised said definitions to include a reference to the national specification for number plates, which is the SANS 1116, which will also contribute to the regulation of South African number plates and the number plate industry in general. Chair, then also just to bear this in mind before we get to those clauses, weighbridge and microdot provisions are new, as the Act did not have specific provisions for registration of these facilities or the microdots. And then on the microdot discussions, there is also cross-reference there to slide 11, slide 18, and slide 51 of the department's references there too. So Chair, that's just for members to bear that in mind. Then just to highlight this for the department, a possible question for discussion on weighbridges, that the department just needs to make sure that we have clarity on the definition and provisions linked to the use of weighbridge facilities. As we did discuss in the definitions, Chair, they did indicate the concerns that the committee raised regarding the mobile weighing equipment. So I think that issue has already been clarified, but if they want to just refresh members, they can do so. Then, Chair, there is also a question here on why do the new proposed sections 5E to H not mention an inspectorate of weighbridge facilities? It is referred to in the definition of a weighbridge facility in the regulations issued on 8 June 2012. And with the proposed sections, replace the regulations regarding the registration of weighbridge facilities per the June 2012 regulations. And do these provisions also cover the use of weigh-in-motion equipment like that which was installed on the N5 by Sunroll at the Senekal Traffic Control Center? So that's just a side note. The department can just make sure that they have some replies there for members on that. But let me get back to the bill. So Chair, the new proposed heading here will be manufacturing of blank number plates, supplying of blank number plates, manufacturing of reflective sheeting for number plates, supplying of reflective sheeting for number plates, and embossing of number plates. So 5A, no person, authority, or organization shall manufacture blank number plates, manufacture reflective sheeting for number plates, supply blank number plates, supply reflective sheeting for number plates, or emboss or sell number plates, unless such person, authority, or organization is registered as such manufacturer, supplier, or embosser in terms of this Act. Then Chair, the next one, the application, 5B, application for registration as manufacturer of blank number plates, supplier of blank number plates, manufacturer of reflective sheeting for number plates, supplier of reflective sheeting for number plates, and embosser of number plates. Any person, authority, or organization desiring to manufacture or supply blank number plates, desiring to manufacture or supply reflective sheeting for number plates, or desiring to emboss number plates shall apply in the prescribed manner to the MEC concerned for registration as a manufacturer of blank number plates, manufacturer of reflective sheeting for number plates, supplier of blank number plates, supplier of reflective sheeting for number plates, or an embosser of number plates. Then going to 5C, this is the registration of a manufacturer of blank number plates, supplier of blank number plates, manufacturer of reflective sheeting, supplier of reflective sheeting, or embosser. On receipt of the application referred to in section 5B, the MEC concerned, if satisfied that in relation to the manufacture of blank number plates, manufacture of reflective sheeting for number plates, supplier of blank number plates, supplier of reflective sheeting for number plates, or embosser of number plates, the prescribed requirements have been met, register such manufacturer, supplier, or embosser in the prescribed manner and give notice of such registration in the Provincial Gazette. 5D, suspension or cancellation of registration. Chair, if it's okay, I'm not going to read the whole blah of all the number plates. I just want to make it that it's going to be the same. They're not leaving them out. 5D, subject to due process of law, the MEC concerned may, if a registered manufacturer, supplier, or embosser no longer complies with the requirements of this Act, suspend the registration of that manufacturer, supplier, or embosser for such period as he or she may deem fit, or cancel the registration in the prescribed manner. So, Chair, then again, the possible concern indicated by members on appeals of these decisions will hopefully be covered by 51A or 51B, 51A and 51B regarding possible appeals for these decisions. Then the weighbridge facility to be registered, 5E, no person, authority, or organization shall operate the weighbridge facility unless such person, authority, or body is registered as a weighbridge facility in terms of this Act. Then 5F, application for registration as weighbridge facility. Any person, authority, or organization desiring to operate a weighbridge facility shall apply in the prescribed manner to the MEC concerned for registration as a weighbridge facility. Then Chair 5G, registration of weighbridge facility. On receipt of the application referred to in section 5F, the MEC concerned shall, if satisfied that in relation to the weighbridge facility, the prescribed requirements have been met, register such weighbridge facility in the prescribed manner and give notice of such registration in the Provincial Gazette. 5H, suspension or cancellation of registration of weighbridge facility, subject to the process of law. The MEC concerned may, if a registered weighbridge facility no longer complies with the requirements of this Act, suspend the registration of that weighbridge facility for such period as he or she may deem fit, or cancel the registration in the prescribed manner and give notice of such cancellation in the Provincial Gazette. 5I, manufacturer of microdots, supplier of microdots, and microdot fitment centers. No person, authority, or organization shall manufacture microdots, supply microdots, or operate a microdot fitment center unless such person, authority, or organization is registered as such. Application for registration as manufacturer of microdots, supplier of microdots, and microdot fitment center. Any person, authority, or organization desiring to manufacture microdots shall apply in the prescribed manner to the MEC concerned for registration as such. Registration of manufacturer of microdots, supplier of microdots, and microdot fitment center, which is 5K. On receipt of the application referred to in section 5J, the MEC concerned shall, if satisfied that in relation to the manufacturer, supplier, or fitment center, the prescribed requirements have been met, register such manufacturer, supplier, or microdot of microdots or microdot fitment center in the prescribed manner, and then suspension or cancellation of registration of manufacturer of microdots, supplier of microdots, and microdot fitment center, subject to due process of law, 5L. The MEC concerned may, if a registered manufacturer of microdots, supplier of microdots, or microdot fitment center no longer complies with the requirements of this Act, suspend the registration of that manufacturer of microdots, supplier of microdots, or microdot fitment center for such period as the MEC deems fit, or cancel the registration in the prescribed manner. So, Chair, that is clause 11, all these new additions. The need to have microdots on the vehicles used to be in regulations. The department has brought it into the Act to make sure that there is more certainty on it. And it allows for the regulation of that industry. So, Chair, that is now for members' input and consideration, clause 11.
Thank you, Advocate Almanel. Honorable Unsinger.
Thank you, Chairperson. We've basically dealt with three elements here: the number plates, the weight breaches, and the microdots. I'm in full support of the line of thinking with regards to all three of these elements. And just a concern around the weight breaches, which in recent years have also seen mobile weight bridges. And a question to the broader committee whether we should not also consider including the description of mobile weight bridges and also add the requirement for these mobile weight bridges also to be registered, since it certainly opens the opportunity for alternatives. In addition to weight bridges, we've also seen the introduction of weight registration through devices fixed on trucks in particular, so that the weight can be determined of a truck with a mechanism which is part of the fixture of the truck itself. Just to be sort of technologically updated, whether we should not also consider those elements, because that then opens the opportunity for truck owners to weigh their own trucks, but then it can electronically be connected to a device at weight bridges, through which one electronically then can assess that the truck has been pre-weighed and still carries the actual weight, and therefore does not have to join the line to be weighed. So just some thoughts on that. And I see it's close to 11 o'clock. If I don't have the opportunity, Chairperson, you must have a safe flight. And we look forward in seeing you in person tomorrow at plenary. Thank you, Chairperson.
Thank you, Honorable Member. In my life, in my other life, when somebody reminds you that you have to go, it shall mean that they are very happy to let you go. But I hear what you are saying.
Great love, Chairperson. Let me interrupt you on that thinking, Chairperson. There's only love between us.
Thank you very much. As you lower your hand, Honorable Mangu, you can also add your voice at the proposal by Honorable Onsinger.
Chairperson, thank you. I also am generally in support of the proposals in front of us. My understanding, in line with what my colleague is saying of mobile weight bridges, is that those are not necessarily weight bridges, but rather screeners, to screen on the back routes to establish whether to take a vehicle to an actual weight bridge or not. And I'm not sure if my information is correct. So if it is correct, however, it means then that there would not necessarily be a need to register those, whether you call them mobile or whatever. But if my colleagues is correct, indeed, that those can legally stand, the ones that are mobile, which I call screeners, then I would support his proposition. And lastly, on the, maybe second last, on the issue of the technology there, I think, of course, technology is the way we are going. But I think many people in the industry are weighing their vehicles anyway, but maybe what is missing is linking it to a weigh bridge, a registered one, so that they can save time. So I think it's very good and innovative in line of that. But my inquisitorial question is the things sent to the MEC, other things sent to the shareholders. Does it mean not all road traffic related functions are under the shareholder? Just for interest's sake, I won't ask which ones are those. Thank you very much, Chair.
Thank you very much. Honorable Chris Hunsinger, is this a fresh hand or you forgot to lower your hand? Thank you very much. Advocate Makatu and your team, do you want to say something before we, let's deal with the inquisitorial question.
Chairperson, no, there isn't anything on my end to be said. Maybe, I don't know whether Mr. Mutsatsing would want to say anything.
On the
inquisitorial, other than the chairperson must have a safe trip.
Oh, was that an inquisitorial? I think Honorable Mangwet asked that what type of issues are taken to the board and to the minister, if I, which ones are taken to the minister?
To the shareholder. Shareholder
Yeah.
committee.
Yeah. I think that was the question.
Okay, no, it's fine. Chairperson, let me start off by saying, say for example now, maybe let me try to outline how the shareholders committee is made up. The shareholders committee, and this is something that honorable members are aware of, and sorry if I bore them with unnecessary. They are made up, they are established in terms of the RTMC Act. They are made up of the minister, who sits as the chair, and the 9 MECs. Anything and everything related to, for example, a application for a principal approval that a person would want, that they be allowed to use an abnormal vehicle which ordinarily would not fit on our public roads. Those are matters that would have to be dealt with by the shareholders committee, but then they are brought to the minister in terms of the appeals provision outlined in the NRTA. And in some instances where an application is made, and you'll see I made reference earlier on to a transitional provision, a decision is made by either the CEO of the RTMC, that gets elevated higher up to the shareholders committee to consider that. But then that person, as aggrieved by the decision made, it would be considered by the department, whether it be deregistration of a DLTC or a non-compliant, or somebody who was found committing any form of crime, be it corruption, and that this person is an examiner. It's matters that would be elevated to them, but then our act says that it's the minister that would have to address those. I hope I've responded to that. Thanks.
Deal with the issue of way bridges. This issue of, or I'll come to you, Ndate John Mtsatsi, whether these mobile way bridges, are they way bridges or screeners, so that we are clear?
I would, on that point, I would agree with the inputs made by Honorable Manu, that rather than referring to them as way bridges, they would be sort of a screener, for lack of a better way. Because if you look at what Clause 11 is trying to say, you know, we want to regulate this environment so that you don't have your fly-by-nights or people coming up with contraptions that in the end are not compliant with the Legal Metrology Act. There would be requirements of calibration, and anything and everything else would have to be approved by the respective MEC within which province that application is made for registration of a weighbridge facility, Chairperson. Thank you.
The point made by Honorable Hunsinger, nevertheless, was that if this, what do you call them now, screeners?
Yes.
Are going
mobile
to be,
way bridges.
yeah, if they are going to be used as way bridges, there must also be a way of regulating them, which I think is a fair point.
That's what, if at all such a thing would have to be, yes, Chairperson, because such would have to serve before the respective MEC of that province, and a whole lot of other things come into play, like, for example, the Legal Metrology Act, their calibration, and a whole lot of things. So
Okay.
we're trying to regulate that space.
Thank you very much. Ndate Mtsatsi, John Mtsatsi of the Republic of South Africa. I can see you want us to call you that way.
No, thanks, Chairperson, honorable members. Just to respond to the question raised by Honorable Manu with regards to functions. Some of the functions, yes, indeed, resides with the MEC, and some of the functions would, as it was envisaged and outlined by Advocate Makato, that the intention of the department, because of trying to standardize and harmonize various traffic management or road transport management, the shareholders committee was created to deal with those issues. But in principle, currently as it stands, some of the functions are specifically, because of their nature, performed by, or are supposed to be performed by various MEC in this instance. But those ones that need harmonization and standardization, the intention therefore is to have those functions reside with the ministers to a certain extent. Some of the functions as it stands are not yet transferred to the RTMC. They are still residing with provinces. And as soon as the MEC have taken a decision to transfer those functions to the shareholders committee, those functions in the long run or in the long term will then be performed by the shareholders committee, as explained by Advocate Makato, representing all the 9 MEC. So just to respond to Honorable Mamungu's point, yes, function reside with MEC, some reside with the shareholders committee, which shareholders committee, as the transitional provisions provide, refers to the minister. Thank you, Chairperson.
Well, on this note, honorable members, as we proceed to clause 12, let me request to be released so that I catch the plane timeously. And thank you very much. Wish you have a good meeting. Valerie, you will then take over and ensure that a new chairperson is taken. I can see many hands. You want, okay, Valerie, over to you.
In your absence, the committee has to elect an acting chairperson. I will give just 1 minute and then I will start the procedure. Are you going to stay for the election or are you going to leave?
I normally leave, otherwise I will influence the committee that they should elect somebody I think can chair when I'm not here. Thank you very much.
Thank you, Chair. I just want to check something quickly. Members, I'm now going to ask for nominations for the position of acting chairperson for the rest of the meeting. Are there any members who wants to propose an acting chairperson? I acknowledge Mr. Mangu.
Thank you, Chief Justice. Sorry, I nominate Honorable Lawrence MacDonald. I am Honorable Lisa Mangu nominating Honorable Lawrence MacDonald to be the acting chairperson. Thank you very much.
Mr. MacDonald, are you accepting the nomination?
I'm accepting the nomination, Ms. Carlson.
Are there any
second it.
seconders? Okay, thank you.
I
Mr.
second the
Hunsinger.
nomination.
Mr. Hunsinger is seconding. Are there any further nominations? Mr. Makosini, Chabango, I see your hand is up. Mr. Chabango, your hand is up. I don't think Mr. Chabango is going to say anything. Are there any further nominations, members?
I was just going to set the nomination of a man from the state. Thank you.
Okay, and who would that be, Mr. Chabangu? Is it still Mr. MacDonald?
Yes.
Good, then you are also seconding that. So if there are no further nominations, members, and Mr. MacDonald has accepted the nomination, then he will continue as the acting chairperson for the rest of the meeting.
Thank you, Ms. Carlson. Thank you, honorable members. I think we will just continue with the previous chair, our real chair has left us, and let's continue, Advocate, now.
Chair, just before I continue, I see the state law advisor has her hand up.
Apologies, Ms. Harishin.
Thank you, Acting Chair. Yes, I did have my hand up. Chair, if with the permission of the committee, if I may please come back to the clause 9. I did ask the committee's permission to come back to this point. May I address the committee on this point, Chair?
Please continue.
Thank you, Chair. Chair, with regards to clause 9 and the proposal by the members to extend the scope of the proposed clause 3M, the Chair would just like to state that when we looked at the bill, we were satisfied with the content of clause 3M as it stands, and when we looked at it, and that the bill seemed to address the need that the bill sought to address at that stage. And as it stands, we were satisfied with clause 3M. And it's important to consider whether the department has a capacity to expand clause 3M. And we would also ask the Department of Transport to provide further information as to whether they have the capacity to extend the scope of clause 3M. And the department should please also consider that whether there are any other implications and requirements that could apply if the scope of clause 3M is expanded upon, and if they can provide for more information in this regard. Thank you, Chair.
Thank you. The department on that comment, on the expansion of the clause 3M.
Okay, Chairperson, sorry. So, acting Chairperson, sorry. Maybe if the state law advisor can elaborate further. My understanding was that the clause reads well and they are happy with it, and the question was whether we would have the capacity Yeah, if maybe that just the part of the capacity can be explained. I'm sorry, Chairperson, if I'm not up to speed with the line of thinking canvassed by the State Law Advisor. Thank you.
Okay, Advocate Mahato. State Law Advisor, if you could elaborate, please. Thank you.
Thank you, Chair. With regards to the contents of Clause 3M, subsection 1, there was the suggestion by one of the committee members that the scope of, if I understood correctly, the scope of Clause 3M be extended to include other institutions which want to apply for qualifications in terms of the ambit of Clause 3M, subsection 1. And there was an indication that possibly other institutions should be allowed to be included within the ambit of Clause 3M1. And in this regard, we request the department to provide information whether they do have the capacity and take into account financial implications and whether there'll be other consequences or implications if other institutions are included within the ambit of this clause. Thank you, Chair.
Thank you very much.
No, thanks. Okay, thanks through you, Chairperson. Right,
Continue.
maybe let's yes, thank you, Chairperson. Maybe let's try to go back to or put it this way. What mischief are we trying to address here with clause 3M and the subsequent clauses? Chairperson, we want to address the issue of fly-by-night training institutions that would want to train traffic officers and so forth. And remember, the argument was that this is confined to provincial departments and local municipalities. For that reason, Chairperson, that you would have somebody allegedly trained as a traffic officer and only to discover that that institution, wherever they might have gone to, is not registered or compliant with prescribed legislations and so forth. So we are trying to address that mischief, get rid of the fly-by-nights, and that these be confined to provincial and local authorities, Chairperson. Yeah, so it's more there than any other thing, Chairperson. And I hope that now clarifies the concern and the issue of capacity that the State Law brought now. Thank you.
Thank you, Advocate Mahato. Advocate Harisharan, I see your hand is still up. You want to add something before I give to the members?
Sorry, Chairperson. No, there's nothing further to add. That was old hand. Thank you, Chairperson.
Any of the members want to add something or deposit something? In absence of that, can Advocate now continue?
Yeah, Chair, our proposition still stands because that's what we propose. While I hear what Advocate Makato is saying, but we cannot preclude those who are not fly-by-nights, genuine institutions, to have an opportunity to train. The enforcement, I mean, these things happen everywhere. There are nursing colleges that are private, there are teacher training. It's happening. We cannot restrict other people. But the knowledge of who will be flying night or not is a total different story, or how those are closed. So, and I also didn't understand the capacity, but our decision then, which should still stand, is that that provision should include other institutions, not limited to local and provincial spheres of government only. Thank you, Chair. Yeah.
Thank you, Honorable Manu. I think we have already made that decision.
Yeah, in fact, I noticed it also excludes the RTMC, which I think is also doing training, which I think I will not raise now. It's fine. I think we stand by that. Yeah.
Thank you, Honorable Manu. I think the committee has already made a decision that there must be an inclusion of these recognized training, like university and by example that we've already alluded to in the portfolio committee this morning. Advocate Nell, you can continue.
Thank you, Chairperson. Then moving on to clause 12, just going to get my screen share up. Chair, clause 12 amends section 6. Just on the notes here, this is expanding the right of appeal to include the new references to blank number plate manufacturers and those of reflective sheeting. It also provides reference to section 81.3, which allows for the granting of some vehicles to be exempt from the provisions of the Act. And then just on a side note that section's numbering may change if there are any new sections inserted that would cause a change there. So that is just a little side note. So Chair will see as section 6 is the right of appeal to the shareholders committee. This is a separate right to the one that was indicated in 51A. Let me just indicate here, the bill seeks to amend subsection 1, only subsection 1 here. Let's just see. Yes, okay. So it's this section that's going to be changed. It's expanded to include the reference there to section 81.3. It also brings in references here to the MEC. 2 and 3 will remain. So let me read the new proposed subsection 1. Any person who is aggrieved at the refusal of the chief executive officer to register him or her as a manufacturer, builder, importer, manufacturer of blank number plates, manufacturer of reflective sheeting for number plates, supplier of blank number plates, supplier of reflective sheeting for number plates, embosser of number plates, weighbridge facility, manufacturer of microdots, supplier of microdots and microdot fitment center, or at the refusal of the MEC to issue an exemption permit in terms of section 81.3, or at the suspension or cancellation of his or her registration as manufacturer, builder, importer, manufacturer of blank number plates, manufacturer of reflective sheeting for number plates, supplier of blank number plates, supplier of reflective sheeting for number plates, embosser of number plates, weighbridge facility, manufacturer of microdots, supplier of microdot fitment center or permit holder in terms of section 81.3, or at the conditions on which he or she is so registered may, within 21 days after such refusal, suspension, or cancellation, or notification of the conditions on which he or she is so registered in writing, appeal to the shareholders committee against such refusal, suspension, cancellation, or conditions, and such person shall at the same time serve a copy of the appeal on the chief executive officer. So, acting chair and members, this seeks to expand the current clause to make sure that all the new additions are in, and the cross-reference there to the exemption permit. I think just to show members 81.3, let me just quickly go down there. Okay, here we go. 81 subsection 3. Vehicle and load may be exempted from provisions of the Act. 81.3 refers to an MEC shall determine the fees or charges payable for a vehicle or load that does not comply with this Act. So, Chair and members, that is clause 12 for members' input and consideration.
Honorable members, are we happy?
Happy with that, Chair.
Honorable Manu?
Yes, I think we should support it. It is perfectly fine. Yeah.
Thank you very much. I hear it's seconded by Honorable Hansinger. And then, Advocate Nel, can we continue, please?
Yes, Chair, just quickly getting everything here. Okay, screen shares up. Now, clause 13 amends section 7. So there's an amendment to the heading, and there's an amendment to subsections 1 and 2. So the old section 7 was appointment of Inspectorate of Manufacturers, Builders and Importers. So Chair, this is what the subcommittee may deem the NRCS clause for purposes of the continued discussion. So Chair, this is what the old one looks like. This is what our new proposed one is, that the minister, or the heading will be the appointment of inspectorates of manufacturers, builders, bodybuilders, importers, number plates, microdots, and weighbridge facilities. The minister may appoint a person or an authority as an inspectorate of manufacturers, builders, bodybuilders, and importers, number plates, microdots, or weighbridge facilities. And 2, the powers and duties of the inspectorates contemplated in subsection 1 in relation to the registration and inspection of manufacturers, builders, bodybuilders, and importers, number plates, microdots, and weighbridge facilities shall be as prescribed. Actually, this might be that section that I've indicated is where Mr. Hansinger's indication should be that the appointment and possible actions or decisions should be subject to the applicable road traffic legislation at the time. And then just to show here in my notes, it does provide for those new inclusions. And there was a note here that the department must just clarify slide 18 in their response to the Department of Transport Western Cape, and slide 23's response to the Department of KZNs, just to show members, slide 18. Again, this is the reference to blank. Western Cape says that the word blank must be inserted in front of the words number plates. And for the microdots, furthermore, the word microdots is used in isolation in the heading of section 7. It's proposed that the word microdots be preceded by the words manufacturer of. And then I just want to get to slide 23. KZN's input. That is your inspectorate of driving schools. Reference to section 28G is incorrect, should be H. Inspectorate of weighbridge facilities is made to section 7B, should read a different section. They didn't include the section here. Instructor reference is made to section 26B, it should be 28. And then speed enforcement was also a question there. So, Chair, that was just to refresh members of those comments that might be linked to those sections. That's 23. So, Chair, that is for members' consideration and input, bearing in mind the concerns of the subcommittee's report.
Thank you, Advocate Nel. Honorable Hansinger.
Thank you, Chairperson. Chairperson, we are dealing with the same dilemma here with regards to the suggested inclusion of a function of inspectors with regards to inspecting manufacturers, importers, and bodybuilders of vehicles, in that NRCS has a similar function. And in fact, with regards to the mandate through the Act, which then justifies NRCS as an entity, how do we find the balance between these two situations of NRCS having inspectors, and now also the introduction of a form of inspectorate from Department of Transport side, because now both departments have inspectors. So certainly this would create a conflicting situation, whereas we would want to see the Department of Transport having the sole initiative to act with their important role of safety of roads, rather than just a economic benefit, as I see it, as the primary role of the Department of Trade and Industry. So, Chairperson, as what Advocate Almanel anticipated, my view would be that what we're dealing with here in this legislation should dictate, and the role of NRCS should be subject, simply because their function and role is one of benefiting the economy with an addition of vehicles and a manufacturing and industrial perspective, whereas our Department of Transport's view is one of road safety. So I think we need to specify this further, so that we maintain the great work and function which is done under DTI with NRCS, but that we limit and expand on the scope of description around the functions of both, and that when it comes to road safety and the vehicle entering public domain, that the Department of Transport's inspectors through this future legislation holds the mandate on inspecting it with regards to safety of usage, and that would include driving and using it as a passenger or someone making use of it. My further question around number plates, microdot, and weight bridges, which are included under this suggested inspectorate, is also one of requesting information on the current status. What is the current status with regards to inspections of number plates, microdotting, and weight bridges, so that we then can anticipate any equal conflicting conditions like what we have now between us and NRCS. Thank you, Chairperson.
Thank you, Honorable Hansinger. Honorable Manu.
Thank you very much, Chair. I think one of the questions I was going to raise is what my colleague raised at the end, the current situation. But I was going to exclude microdots, but more on the weighbridge facilities, because my understanding is that there is a process of calibration, certification thereof, of weighbridges, of facilities, in the same way as you do your speed measuring devices, which would satisfy the requirement. So I'm not sure what the inspectorate will be inspecting at weighbridge facilities. However, my addition to what my colleague has said, which I totally agree with, is the issue of number plates. And one of the comments raised in what Advocate Nell was reading, I'm not sure from which province, they were proposing a blank number plates to be mentioned. I support that view, unless there's something that the department can explain to us, which maybe is hidden to our naked eye. If you go to the definitions quickly, you will see that the embosser, which is interesting, is an embosser of number plates, but there is a reference to manufacturer of blank number plates. Now, if I go back here now and look at the inspectorate, it leaves it open. We are not sure here if the inspectorate is the inspectorate of the manufacturer or of the embosser. And I think that is where my supporting of blank number plates comes into being. Those will be my comments, Chairperson. As I said, I support what my colleague was saying. I was just making those one or two comments and additions. Thank you.
Thank you, Honorable Manu. Before I give to the State Law Advisor, if she wanted to add something, and then we can make comments on the approval of these amendments suggested by the committee. Anything that you want to add, State Law Advisor?
Nothing to add at this stage, Chair. Thank you.
The department?
Thanks, Chairperson. Maybe let me take the committee a bit back. As we made reference earlier on that in terms of Section 7, that was read, the minister is empowered to appoint any person as or an institution as the inspectorate. And in this regard, NRCS has been appointed, but that within the department, there are inspectors. In fact, I dare say there is a unit compliance, which has inspectors. And in addition to the functions that they perform, they would include making inspections at various DLTCs and VTSs and registering authorities to check their compliance with our legislation and the regulations applicable, including the standards, right? Now, insofar as that is concerned, you now go to the inputs that we made and the slides that Advocate Nell made reference to, 18 and 23. The proposal by Western Cape that the insertion of the word blank, and our response there too. So we're saying the Inspectorate of Number Plates is not only going to inspect the manufacturers of blank number plates. We are of the view that all of them will be inspected. Right? And I think, yeah, in fact, I don't think there was reference to slide 23, which was an input by KZN. They are saying, as part of their comments, they are saying the Inspectorate of Driving School, where's that one? Because now okay. The Inspectorate of Driving School, although we've not come to that as yet, we are saying, well, we note and accept, and then look, effected there, I think it's just to correct that, it should be by the portfolio committee if it accepts the proposal being made. And on the issue of the Inspectorate of Weighbridge Facilities, reference in section B, it should read section, and then we're saying we accept that. And yeah, let me leave it at that, because the relevant clause which is under discussion is clause 7, Chairperson. That will be our submission, amplified by the responses we've provided and the relevant slides that Advocate Nell made reference to. Thank you.
Advocate Magatu, I think just to assist the department here, I think the committee's feeling is that there should be a clear indication, the difference between a blank number plate and an embossed number plate. I think that's the feeling of the committee, if I'm correct, honourable members.
Okay.
And I'm subject to correction. And I would like, from the committee has already made a decision on this, and we feel that the department should find a way of explaining it a bit better, Advocate Magatu. So if you can just, I'm sure you can come back to us on that one, and that we can continue with the next section.
It's fine, Chairperson. Yeah. In case, John, I don't know whether maybe you would want to give it a shot, or maybe I might have misconstrued something. Sorry, Chairperson.
Advocate Magatu, it was raised by Honourable Manu and Honourable Hansinger regarding the word blank in the as much as we understand that it's not an inspection of only blank number plates, that there's a clear distinction between the embosser and the manufacturer, is what I think the committee has raised with you in this section. If I'm incorrect,
no, it's fine. No, it's fine, Chairperson. I accept that. We'll look into that. Thanks.
Thank you very much, Honourable Advocate. Now, can we continue?
Chairperson, can I ask something on clarity?
Yes, sure, Honourable Hansinger.
Thank you, Chairperson. Chairperson, as I understood it now from the advocate, is that the Minister of Transport has the authority to appoint inspectors, and as such, he then appointed the inspectors to do the work of the NRCS. Did I understand it correct?
Let's Advocate from the department, Magatu.
Okay, thanks. No, thanks, Chairperson. What we said is that in terms of Section 7, the minister is empowered to appoint any person, right, an authority or a body as an inspectorate of manufacturers, builders, and importers. Right? But within the department, there is a compliance unit, meaning that there are officials within the department who are appointed as inspectors. And as part of their functions, they make inspections at different DLTCs, registering authorities, and vehicle testing stations. We have people doing that under the unit compliance unit. Thank you.
Thank you, Advocate. I have the hand up, John Matsuri.
Thank you, Acting Chairperson, honorable members. Just to amplify what Advocate Makhat was saying in terms of the inspectorate, remember the NRCA is an institution within the DTI. Now, for them to be able to perform certain functions within the NRTA, they need to be appointed in terms of the National Road Traffic Act. That is why that specific section talks about the minister being empowered to appoint certain institutions as inspectors, Chairperson. I just wanted to amplify the comments made by Advocate Makato in relation to the inspectors or the that the minister may appoint. Thank you, Chairperson.
Honorable Hansinger.
Thank you, Chairperson. Just a follow up on that. These inspectors can equally function as an extension of the Department of Transport. It is therefore not necessary to be part of a function executed by NRCS.
Thank you, Honorable Hansinger. Advocate Makato.
Okay, Chairperson, look, maybe simply put, the response to that will be yes, but then they will be remember, whatever it is that, and I made reference to Regulation 44 of the NRT regulations. If NRCS were to go out and do any inspection, the expectation is from the department is that which they went out to inspect, they would put it in the form of a report, which we would have to look at within the department under the compliance unit, right? And then if at all there are anomalies that we're not happy with, we would go back to the NRCS as the case may be, right? So that's how it's structured. And you remember, as I was making reference to the responsibilities of the NRCS, I touched on that we expect them to submit reports to us, either be it on a monthly basis and so forth. Thank you.
Thank you, Honorable Manu.
Thank you very much, Chair. Yeah, I think maybe through you, Chair, if I could just get clarity from the department, and it's what I think Honorable Hunsinger has asked, but maybe the question I will rephrase and maybe we'll get the exact answer. Is there an inspectorate in the DOT other than the Inspectorate of Driving License Testing Centers? And then I will be able to continue because I just seek that clarity. Is there an inspectorate other than that of DLTCs in the department? If I could just have a direct answer there, I should be able then to carry on with my line of thinking in this regard through you, Chairperson.
Thank you, Honorable Manu. Let's get Advocate Makato.
No, the answer is no, Chairperson.
All right. Yeah, thank you then, Chair. Through you, Chair, then it means what was said earlier, maybe in response to Honorable Hunsinger, was maybe the understanding was not very clear on his question. Now, Chair, I think this is where it becomes a bit challenging. And I think the challenge comes in that it is not clear, to me at least, what then becomes the role of this NRCS or CSIR, whoever would be appointed, as they have clearly said, the minister can appoint anybody to do this function. But there are actually functions by legislation that my colleague Honorable Hunsinger mentioned that are residing in NRCS. And I think that is where we are finding this quagmire, for lack of a better word, because we are guarding this space of transport jealously, and we are feeling that this legislation doesn't close the gaps or remove the gray areas so that we know that the department, either directly or through the NRCS or whoever, can directly intervene in instances where there is malfeasance, as we have seen in the illegal conversions and any other issues. So I think that is where this gray area comes in, which I think as a committee, we need really to put our heads here and find what will be the best way of structuring what is already in front of us without complicating the department's lives. Because I think we know what we want to achieve because of what we have been exposed to. The department where they are, they've done the best they can to present what is in front of us. And asking them to relook at it, I think, is asking too much. Maybe us and the drafters within the legislature should assist us with the thinking that we have to tighten this thing and give the department even more teeth, should the NRCS not do their work or whoever else to be able to bite. Thank you, Chair.
Thank you very much, Honorable Manu. Can I ask the members that if we second this proposal of yours, Honorable Manu, so that we can give it back to them. Let's get all the members to give inputs on this specific matter to give the department more teeth. I got the Honorable Makosini's hand up. Honorable Makosini.
Chair.
Yes, Honorable Makosini, we are audible.
Yes, I would like also to join the latter speaker, Honorable Manu, with regard to the way the minister can appoint any person. Can that be clarified? Any person can be appointed by the minister irrespective of qualifications. Can that be clarified so that when we adopt this, we should be clear that what does it mean by any person? Thank you very much, Chairperson.
Thank you, Honorable Makosini. Honorable Hansinger.
Thank you, Chairperson. Chairperson, I am in support of what Honorable Mangu proposed. And I think it is important then to have a conversation with the parliamentary law advisors. Advocate Harichanan in this case. And I think we should share the experience that the subcommittee has had with regards to having to deal with the panel van conversions to taxis. And also other matters that we know of that has occurred or developed from the Department of Trade and Industry with its entity NRCS being involved in a process of homologation and approval of manufacturing of vehicles, MIB certifications, and then changes to existing vehicles to then be transformed in a different use, which now has developed in a situation where there's a huge gray area, overlap on the one side and just a gap on the other side. Overlap of function, which now has also manifested in a huge concern about the safety of especially the public transport environment, but then also the ambulance environment, in that we have thousands of illegally converted taxis and ambulances on our roads. And to a certain extent, it let's just leave it at the factual elements of this point. So in having this opportunity then to bolster the NRTA and to get grip on the situation, we would like to see a dispensation where NRCS maintains a role and function with regards to the economic role within the framework of the Department of Trade and Industry, but that the road safety element with regards to inspections of manufacturers and people that are involved with renovations or changes to MIB certified vehicles and patents, that becomes the responsibility of the Department of Transport. We therefore fully support the envisaged future of the minister making appointments of inspectors, but that these inspectors would then have the full authority to act, and that we do not have this grey area of inspectors of NRCS and future inspectors of the Department of Transport. We definitely do not want to be a part of further confusion, but in particular of some of having a role of fixing the current unsafe conditions that we have. So, Chairperson, I think that is a bit of background, and I think we should expand this with further conversation as we deal with this going forward. But that would be sort of impetus and expansion on the great suggestion by my colleague Mangu, and supported by Honorable Makosini from the Fighters delegation. Thank you, Chairperson.
Thank you, Honorable Hansinger. Before I give to the department to answer Honorable Makosini's question, the State Law Advisor, I'm sure she's heard the whole conversation. I wanted to, if she wanted to add something, and then I'll give it to the department.
There's nothing to add at this stage, Chair. Thank you.
Thank you. Department? Specifically on the question of Honorable Makosini, and then also to take note of the decision of the committee on strengthening this.
Okay, thanks, Chairperson. I think, like the earlier submissions that I made, proposal coming forth from the Portfolio Committee are welcomed, including the one that Honorable Manu has made, Chairperson, to strengthen the bill. So that part, I mean, we are happy with that, and that will help, and it will go a long way. Now, on the question asked by Honorable Makosini, the Section 7 says the minister may appoint a person, an authority or a body as an inspectorate of builders and
Advocate, you are breaking up a bit. If you can start over, please. I'm sure Honorable Marcus. Yeah.
I was sorry about that, Chairperson. That Section 7, it says, well, as it reads now, that the minister may appoint a person, an authority or a body as an inspectorate of manufacturers, builders, and importers. Right? Now, a person within the legal sense would mean either a juristic or a natural person, right? A natural person would be me, and a juristic person would be an institution or something of that. So in this regard, NRCS as a juristic person were appointed by the minister to assist us in carrying out our functions as outlined in the Act. I hope that clarifies it, Chairperson. Thank you.
Advocate, I think what Honorable Makosini was trying to, he was referring to that, he was asking, can any person irrespective of his qualifications, be appointed, because it's a person. And I think that the question of Honorable Makosini was, can
Okay.
a person...
No, sorry. Look, like I said, a person, chairperson, if in terms of legal sense, would be split between a human, me as a natural person, and a juristic person. But then there are requirements that such a person would have to comply with, because it's not necessarily like me rocking up and saying I want to be appointed. My bad for not understanding that. There are prescribed requirements that such a person would have to comply with, Chairperson. Thank you.
If I can just assist Honorable Makosini, Advocate Magoto, can you just refer to the sections where it refers to that a qualified person or a person with qualifications or etc., so that we can close this issue and Honorable Makosini is well covered, and then we can continue, please. Advocate Magoto?
Saying I can, sorry, I had muted. I muted myself and yet I was talking. Person, I was saying, in fact, I note also the hand of Sis Pumele. I was saying I can look at the section and before we finish off and bring it to the attention of Honorable Makosi.
Honorable Makosi, yes, thank you very much. Can Pumelele, your hand is raised.
Thank you so much, Chairperson. I was not going to answer on the question of the requirements and the qualifications where they are set out. I am still looking at it. I just wanted to clarify, Chairperson, the position of the committee in respect of clause 13 and which seeks to amend section 7. Is the committee, with all the inputs and comments made, sort of inclined to go towards the decision that says we need to look at subsection 1, section 7.1, and limit the power of the minister to be able to indicate and appoint the inspectors and the inspectorate outside of the district? Because I'm a bit lost now exactly as to what would be re-looking at drafting this position we would be seeking to achieve. Are we limiting this power to appoint the inspectors and the inspectorate, as has been explained, that the term person can mean a juristic body and it can also mean an individual person? I'm a bit lost in terms of trying to think through what could be the solution into the comments of the members, and I was seeking that clarity, Chair. Thank you.
Honorable Manu.
Thank you, Chair. As I lower my hand, because I know you are vicious when it comes to it. You don't like hands. No, subject to my colleagues agreeing with me, there is no limitation we are seeking here, Sis Pumele. But our frustration is from the experience of the ineffectiveness, at least according to us, of the current inspectorate, in particular NRC, as it relates to inspecting what has now become a problem on the road. So ours is to strengthen rather than weaken, number one. Number two is to try and guard jealously what can be enforced through this legislation. Hence, my colleague, Honorable Hun Singh, had said earlier, I don't know the words, but NRC is subject to the traffic law legislation, something to that effect. So by no means do we want to limit the minister's power in appointing, but we are coming from a point of having been exposed one. Hence, my colleague was saying, maybe we should share with yourselves our experience of what we've had during our sittings looking at the illegal conversions of panel vans into minibus taxis and ambulances and many other things. That has resulted in compromising road safety and lives of people. So this clause draws a lot of our interest in that we are looking at a way of closing the loopholes we have seen with the current environment, which is including the NRCS. I hope I've not complicated the matter for you, but we are not at all looking at limiting, but rather strengthening. Thank you, Chair.
Thank you, Honorable Manu. Sis Pumelele, are you covered?
Thank you so much, Chairperson and Honorable Member Manu. I am very clear now. Thank you so much.
Thank you very much. Honorable Hansinger?
Thank you, Chairperson. Just also to expand, it's not just about taxis and ambulances. We currently sit with a situation where NRCS is signing off on new vehicles that are equipped with lights that are not legal and contradict our current traffic laws. So it is a malfunction and a gap between the two entities which we need to close, and we need to find proper ranking for in terms of which is subject to which. And I think it can be resolved. So, but clearly, Chairperson, it demands a bigger discussion, which then needs to wedge in, given the understanding and insight which we have, which we would like to share with the bigger group in assisting them with future legislation and a safer environment. Thank you, Chair.
Thank you, Honorable Chris Hansinger. On this point, I think we can step off this point. I think we're all in agreement. We can advocate now. Can we then move on to the next item, please?
Thank you, Chair. I think what might assist, and the department could possibly just touch on this in our next engagement, it might also assist our drafters, is if the department can just spell out in practice who or which bodies do the inspections of the MIBs. In this case, we'll say the NRCS, because that is what we know about the MIB inspections. But in them doing that, their focus as the NRCS is to look at the manufacturing standards and whether or not those are complied. And if there are safety standards linked to those items, that whether or not those safety standards have been complied. So, Chair, the question for that one might be whether or not there needs to be an amendment, either in this bill, if it's possible, that we can link to the NRCS Act that could say that when they are doing inspections of MIBs and new vehicles, that they make sure that the inspection and approval of such vehicles to enter the market or be registered does then comply with the applicable road transport legislation and regulations applicable at the time. The second one is that if the department can then possibly just indicate who or which body does the inspection of number plates, and whether there's a separate one for microdots or whether the number plate and the microdot guys are the same. And then there's obviously, or there should be in my mind, a separate inspectorate for the weighbridge facilities. I know the regulations do have a bit more broader stipulations on that, and whatever is amended in terms of this bill will then go through and lead through to additional amendments of the regulations. But I think it might assist just possibly in the next discussion or for the drafters that we have a nice understanding of what is practically happening on the ground. That way we can make sure that when we do the amendments or the proposed additions that we don't overstep or add too much on the plate of whoever is doing those functions. Chair, I thought I'd just bring my 2 cents in on that to try and help the process going forward. But then I'll move to clause 14 and just get my screen share up here. Clause 14, Chair, amends or substitutes section 8. So Chair, section 8 was the driving license testing center to be registered. So that this is the old clause, very short. The new proposed clause is a provincial department responsible for transport or a municipality shall not operate a driving license testing center unless such driving license testing center is registered and graded in terms of this act. So, Chair, members will know that the grading links with what they can do at the specific center. If they're just doing learner license testing, if they're just doing fines and renewals, or however which way that operates. The old act just said no person, department of state or registering authority shall operate such centers. So, Chair, the specific focus is now on the provincial departments. I believe the department did indicate that it is because in terms of driving license testing centers, there are not private companies that run these, different to vehicle testing centers, Chair. Then just on the notes, that is exactly what I had on my notes there. But also I just want to pop up slide 36, which was the input from Ms. Swanepoel. Let's go to slide 36 quickly there. Chair, here the proposal is to read different to what is in the bill. So I just want to highlight this driving license testing center to be registered. That's the same as in the heading. But here, a provincial department responsible for transport or municipal registering authority shall not operate a driving license testing center unless such driving license testing center is registered and graded in terms of this act. So Chair, just better phrases the reference here to the municipality registering authority. The department did indicate here that they agree with this, so we just need to find out from members if they would be happy to agree with such an amendment to the clause. So Chair, I will leave those up on the screen just so that members can see that for consideration before we continue to the next clause.
Thank you, Advocate. Now, members, Honourable Hansinger.
Thank you, Chairperson. Chairperson, in addition to registration, which I think we have laboured and find consensus on, there's also mention of grading, particularly in the contribution of one of the public participation submissions. To what extent is grading incorporated and included as a performance level standard mechanism within this current legislation? So what I'm asking is, to what extent is the grading element used as a mechanism to maintain a particular standard within these driving schools?
Honourable Manu.
Thank you very much, Chairperson. As I lower my hand, I'm tempted to respond to my colleague now on the last part. I hope I don't lose what I wanted to raise. I think the grading is for the testing center, but not the people who are actually on the driving school. It's the testing center, that is the grading. But I'm sure, and obviously you'll say if you can test trucks here or test which category of vehicles, I think that is what it confines itself to, not the actual driving schools. But I'm sure they can clarify. Now, mine is more of a mischievous question, to be honest. My brain is on overdrive. Is it a municipality or a local authority? When it's a municipality, is it not limiting it, or is it just semantics? That was all I wanted to ask. But overall, I'm happy with that clause. Thank you, Chair.
State Law Advisor, you want to add something before I give to the department? The department, in absence of the state law inputs.
Thanks, Chairperson. And through you, and in responding to the question posed by Honorable Hunsinger and amplified by Honorable Manu, grading correctly so it's more on the DOTCs, and the empowering provision is 95 section. Let me be sure whether it's the regulation or the section itself. Yeah, it's titled grades of different licensing testing centers. It says the MEC shall, with due regard to the evaluation and recommendation of the Inspectorate of Driving License Testing Centers, grade a driving license testing center as a grade A, B, C, D, E, or F. And if you read further down under 95.2, it distinguishes or it differentiates between the different grades, wherein A is said to be a DLTC authorized to examine and test persons for learners licenses of any code. And it does that distinction. It will be something for reading, maybe at a person's leisure, Chairperson. Thank you.
Thank you, Advocate Mahato. Advocate Harisharan.
Thank you, Chair. Just to concur with the department's comments therein. Thank you, Chair.
Thank you very much. Honorable Hunsinger, are you in agreement with the proposed amendment as proposed that the department has accepted, and so that we can get consensus? But before that, Sis Pumelele.
Thank you, Chairperson. I just wanted to come in on the issue of the definition local authority and municipality. Fortunately, the Act does define local authority for us, but the distinction, as the Honorable Member noted, we perhaps need to look at it because local authority speaks to all kinds of municipalities as they stand, but then municipalities, they are also differentiated as per the terms of the Constitution, which outlines it there. So we need to be very clear in understanding what the context and what we seek to convey. I just wanted to come in on that, Chairperson, and note that there is a distinction between the state law advisor and the parliamentary advisor, Chairperson. So that's why sometimes I just not come in. Thank you, Chair.
Thank you very much, Sis Pumelele. Let me just see any hands?
We call that through you, Chair, a nuance, Sis Pumelele. Can somebody give me a title of advocate, please? Advocate Makato, please comment at the end of the meeting, please.
As members, are we in agreement on what was proposed? If we are, can we continue?
Yes, sir.
Thank you very much. Advocate now.
Thank you, Chairperson. I'm just going to put that slide up again so that we now just make sure that our members agreeing to this proposal by Ms. Swanepoel. She did also indicate here, Chair, that Section 1 contains a definition for local authority, but none for a municipality. The term municipality is not used in the existing act. The local authority, she gives the definition there in terms of the Local Government Transitional Act. And then she does the proposal here, but she still keeps the reference here to municipality. So Chair, because the wording of her proposal differs to what is in the bill, I just want to be 100% sure for our A-list compilation. Are members agreeing to this proposal that I'm flagging on the screen? Or are we looking at, I just want to put the other one up as well for members? Or are members in agreement with the department's proposal as it is in the bill? Just before we go forward there, Chair, thank you.
Thank you, now, Honorable Hansinger.
Chairperson, I'm in agreement with none of the two, and I will propose that we use the submitted one by Alta Swanepoel with inclusion of local authority, and that we do away with municipality, because local authority then includes all forms of municipality, being A, B, and C. Thank you, Chair.
Honorable Manu.
I second my colleague. I was going to suggest exactly that. That's like, yeah, thank you.
Thank you very much, Honorable Manu. Sis Pumelele, your hand is up. Do you want to add something, or is it an old hand?
Legacy hand, Chairperson. I'm so sorry. I'm bringing
Legacy
it down.
hand.
Yeah.
Honorable Hansinger, okay? Is yours also a legacy hand? So, Advocate, now the proposal is that the municipality is removed from that submission, and then the local authority is then put in as proposed. Advocate now. Then let's continue next section.
Thank you, Chair. Okay. So our next clause, let me just take that one down quickly. These are my notes here. Clause 15. 15 will be amending section 8A. The Chair, just my notes in short, similar to the above clause, there must be reference to the submissions that the department indicated as accepted from Ms. Swanepoel on slides 37 and 38. It must be noted that on the face of it, new section 8 and section 8A3 appears to be a repetition. Our parliamentary legal advisor and state law advisors can just clarify whether or not it is a repetition, or if they still serve a purpose despite the wording seeming similar. And a new subsection is proposed in addition to 8A in the form of new subsection 4, allowing for the registration of mobile facilities. So Chair, the mobile facilities are those mobile driver license testing centers that they often take out on the roads as well. So Chair, then going to the old 8A, it is the application for registration of driving license testing centers. So that is just to flag 8A. We'll show it for members. I know my document seems to be having a few gremlins there. At least the bill still looks okay. Chair, so the proposed new subsection 1 will be any provincial department responsible for transport or registering authority desiring to operate a driving license testing center shall in the prescribed manner apply to the Inspectorate of Driving License Testing Centers for approval and the registration of such testing center. So Chair, we'll see here, they make use of registering authority in this clause, which differs to the conversation that we just had on the municipal or local authorities. So we might need to just decide which is going to be which and then apply it as it can be applied for the other clauses. Then there is, they leave 2. So 2 will still be a driving license testing center, may on the prescribed conditions be registered and graded to test applicants for learner licenses only. And then there's a substitution of 3. So it will then read, a provincial department responsible for transport or a registering authority shall not operate a driving license testing center unless such testing center is registered and graded in accordance with the Act. Chair, this is the one that I indicated does seem like it's almost a carbon copy of 8. Only difference here, municipality versus registering authority. Then, Chair, they also propose the addition of new subsection 4. So the proposal is that a driving license testing center may, on the prescribed conditions, apply for the Inspectorate of Driving License Testing Centers to be registered and graded to operate a mobile facility that may test applicants for learners' licenses in case of a provincial department within the province concerned, and in case of a registering authority within the area of jurisdiction of the registering authority. So, Chair, these are the mobile units that we've seen go around to assist some of those municipalities where either there's an issue with the driver license testing center, or the municipality, for example, does not have a driver license testing center. And those citizens then often have to travel quite a distance to get to the nearest one. The mobile units have been brought in to assist with that, as well as some of the rural testing for the students. Chair, that is the clause 15 for members' consideration. If I need to just pop quickly up, this is the proposals by Ms. Swanepoel. The department indicated that it is to be aligned. And then in 38, she also made an amendment or proposed an amendment further there, which the department accepted. So we just need to hear from members whether or not they would also be in agreement with what Ms. Swanepoel proposed. Thank you, Chair.
Thank you very much, Advocate. Now, Honourable Chris Hansinger.
Thank you, Chairperson. Chairperson, I'm in full agreement with the submission of Ms. Swanepoel, and also with the need for these mobile driving license units to be registered and brought into use, but then also regulated in terms of the description. I'm just looking at the phrasing of the introduction. Any provincial department of responsible for transport, would that include a provincial department of education responsible for scholar transport? Because that is the type of dilemma that we end up in shared responsibilities like we currently have with some provincial departments of education responsible for scholar transport. Because in essence, it would mean that they would be able to then operate driving license testing centers, which is ridiculous. So I think we just need to look at, well, both of those issues, but in this case, at least the phrasing of provincial department as a registered authority involved with transport. Thank you, Chair.
Thank you, Honourable Hansinger. Honourable Manu.
Thank you very much, Chair. I think my colleague is trying to outsmart me as a candidate advocate with that transport issue. That was on a lighter note. My attention, I would like to talk to 15C4, a driving license testing center may, on the prescribed conditions, I don't know what that means, on the prescribed conditions apply to the inspectorate. I don't know what are prescribed conditions, that's number one. Apply to the Inspectorate of Driving License Testing Centers to be registered and graded to operate a mobile facility that may test applicants for learners' licenses. Why is it limited? Maybe let me not say why. Shouldn't we, add on there in renewal of driving licenses also, because I think that is what we were told at some stage, that either the DLCA or RTMC, I don't know who, was busy doing at some stage. That is what I would like to see added there. And that question that I had there, what are prescribed conditions? Thank you very much, Chair. The other clauses, I'm fairly fine with, barring my colleague's question there. Thanks.
Thank you very much, Honorable Manu. Let's give it to the department to respond, and then the State Law Advisor.
Okay. Thanks, Chairperson. The prescribed the conditions, Chairperson, would be okay. Maybe let me start off by saying this: the Act, Chairperson, as it is now, it's the bone, right? In terms of what it envisages should happen. Now, in the regulations, that's where questions of who, and hence the use of the word, prescribed. That's where in the question of who, what, when, and how are going to be addressed, Chairperson. So as it is, the department has published, and it's a while back, a set of regulations making this act workable by detailing some of those issues and conditions, if they are not already set out in the current set of regulations, Chairperson. That would be my response on that, and I hope it suffices. And we would welcome additions that the portfolio committee would want to make, so that this act is more workable and more tighter. Thank you, Chairperson.
Thank you, State Law Advisor.
Before they come in, Chair, sorry.
Okay. Apologies, I didn't see Honorable Manu before the State Law Advisor.
Maybe they can also assist. No, for me, the question is not answered. The English or the grammar there, to me, sounds very, very not right. I know I studied Bantu education, but at least you may, on the prescribed conditions, apply. Do you apply on prescribed conditions or on a prescribed format or whatever? That is where my conditions question comes from. Unless it's a legal language here that is sound and correct in legal terms. Thank you, Chair.
Thank you, Honorable Manu. Sis Pumelela, I saw your hand up. Do you wanted to say something?
Thank you, Chairperson. I'm a bit distracted by the last question of Honorable Mangi, even though I was gonna skip on that one. I think there is a point Chairperson made there. My explanation would have been limited to explaining prescribe, as my colleague Advocate Mahato had explained, that whatever is referenced as prescribed, it is coming out of the regulations. So in this instance, with respect to the conditions, whether they would also be regulating the conditions through the regulations as a delegated authority to the department, is something that the department must clarify to us, or there is definitely a need to amend the word condition into something else that relates to the application itself. What I would have wanted to come into and deal with, Chairperson, was the point that Advocate Nell made, that under clause 15, the amendment to section 8A4, is subsection 3, the B part, is actually the same as that one appearing in clause 14. So we need clarity from the department whether we retain both of them for purposes of the two different sections, and what is the objective behind that to be achieved, or we should delete one of the two in order to clean up the provisions. Thank you, Chair.
Thank you very much, Ms. Pumelele. Before I give back to the department, I just wanted to hear if Advocate Hari Sharan has got something to add, and then I'll give back to the department.
Chair, just to echo the sentiments of the department and to state that the Act does define the term prescribed with reference to the regulations. The Principal Act does define the word prescribed, and this should assist with this issue. It does refer to regulations in this regard. Thank you, Chair.
Thank you very much. Department? Advocate Makgato?
Thanks, Chairperson. Chairperson, where we are, and please, it must not be construed as one abdicating their responsibility. But then I would want to move from a premise that whichever comes from the committee as a proposal, be it effecting amendments or doing away with a provision, as a department, we would welcome that. And then in this instance, if on the proper reading of the two provisions, the view by either the parliamentary legal advisor or the state law advisor, as the case may be, is that this amounts to a repetition. And this being the bill of the portfolio committee now, we would welcome that input or deletion, Chairperson, for as long as it gives meaning and it carries out what we are seeking to address, Chairperson. Thank you.
Thank you, Advocate Makgato. Honourable members? Honourable Manu?
Yes, Chair. It has been a long day. I propose we rephrase the prescribed conditions to as prescribed, applied to the Inspectorate of Driving License Testing Centers. A driving license testing center may, on the as prescribed, apply to the Inspectorate of Driving License, blah, 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 that may test applicants for learner's licenses and or whichever word is applicable, renewal of driving licenses. That is my submission, Chair. I thank you very much. Other than that, I agree with the rest.
Thank you very much. Honourable Hansinger?
It's been a long day. Thank you, Chairperson. Indeed, I concur with my colleague's suggestion and proposal and firm recommendation, Honourable Mangu, and I second his proposal for the phrasing as he has recorded it. Thank you, Chairperson, and thank you for you chairing this committee so well.
Thank you very much, Honourable Hansinger. Advocate Hari Sharan?
Thank you, Chair. Just to mention that we are satisfied with the wording of that clause as it stands, but we are subject to the committee's directions in this regard. Chair, just to clarify the actual wording, to go back to the actual wording of clause 15, subsection C, department can also chime in here if necessary. I think the intention of that clause was to clearly state that a driver, in terms of section 15, clause 15, subsection C, subsection 4, a driving license testing center may, on the prescribed conditions, apply to an inspector of a driving license testing center to be registered. Then it seems the legislative intention here is that the prescribed conditions must be met before this application is made, to set out the procedure and to comply with the provisions of the Act and the Amendment Bill. So that is why I would deem that the words prescribed conditions are included there. And it makes it, in terms of legislative drafting, it makes sense, and we are satisfied that it's constitutionally sound as it is drafted. But we are subject to the committee's further directions in that regard. Thank you, Chair.
Thank you very much. I'm going to give to the department closing remarks, and you've heard the committee the department. So if you can just closing remarks on this item, and then we can step off it.
Okay, thanks, Chairperson. There are no further submissions in this regard, Chairperson, from the department. Thank you.
Thank you very much. Honorable members, I think with the jealousy of time, I think I would suggest that we do not continue, because we might not have time to thoroughly dissect and investigate further clauses and sections. And I would ask if it would be fine if we leave the rest over till the next engagement, and thus end the committee meeting and leave all the other business for Tuesday, if that is fine with the committee members.
Where is the lunch served?
Please repeat, Honorable Mano.
Where is the lunch served?
Zoom
lunch
will
is
provide.
At home, Honorable Mano.
Zoom will provide.
Zoom will provide.
I agree, Chairperson. It has been a consuming day. Yes, you must be gentle with us. We've been long away on a break, and we are still warming up. I agree, Chair, and thank you for steering the ship properly.
Thank you very much, Honorable Manu. Honorable members, with that, we conclude today's meeting. All other matters that were for today will stand over until Tuesday, and have a wonderful day, the rest of the day, and see you all tomorrow in plenary.
Thank you,
meeting.
Chairperson. Goodbye, everyone. See you tomorrow.
Long
Bye.
live the Chair, long live.
Long live.